It's exciting to welcome everyone today to this program. It's titled Human Rights Treaty Reviews and the United States, the Rocky Road to Rights. And veterans of this network, folks that have been involved for a while, will recognize that this title sounds familiar. More than a decade ago, I think it was in 2012, the Columbia Human Rights Institute and others who are active in this network put together a major report on U.S. human rights mechanisms, particularly on the idea of a national human rights institution that they titled the Road to Rights, or we stuck Rocky in, so they titled it the Road to Rights. And then in today's program, we're revisiting that effort while acknowledging that the road to U.S. human rights implementation has been rockier than probably folks imagined back then. Though, and we'll come back to this later in the program, the Supreme Court has surprised us with its recent decisions on voting rights and today's decision upholding the Indian Child Welfare Act. So more to come on that, little bright spot in U.S. human rights compliance. So we've got a tight schedule, but I want to make sure at the outset to thank the folks at the Northeastern University School of Law who worked hard to make this happen, particularly PHRGE Director Elizabeth Ennin and our two research associates, Jacob Hayward and Jennifer Loveland Rose. Jennifer is here today and is handling tech, but Jacob graduated and is now sitting for the bar. And those of us who are lawyers are probably just as happy to be here instead of doing the kind of thing that Jacob is doing now. Jennifer and Jacob oversaw the process of getting CLE accreditation for this program. California has accredited the program and will be seeking accreditation from New York. For that reason, Jennifer will be appearing periodically through the program to read out special codes that you who want New York credit will have to write down in order to receive credit. This is not something we made up. It sounds crazy, but this is a New York requirement. So people will need to pay attention to make sure they get those codes. I also want to acknowledge the organizational co-sponsors of this event who are listed on the program. And you can look on the flyer, or you can use a QR code, I think, to get that information. And they helped us publicize this far and wide. So we expect a good turnout today, and we know that many, many people received word of this program, and it'll be available in recording afterwards. So hopefully we'll get a lot of hits. We chose today's topic in part because under the current presidential administration, the U.S. has re-engaged with international treaty bodies and other international mechanisms, so we can have a constructive dialogue about how to improve U.S. human rights engagement. In particular, in October, this coming October, the UN Human Rights Committee will be reviewing U.S. compliance with the International Covenant on Civil and Political Rights, the ICCPR, which the U.S. ratified in 1992. So to start today's program, I want to introduce Jamil Dakwar, the Director of the Human Rights Program of the American Civil Liberties Union, who is deeply involved in preparations for the upcoming review. Jamil will first say a few words about that process, and then I've asked him to introduce our exciting keynote speaker and to handle the moderation of Q&A after her remarks, and then I'll come back online afterwards to introduce our next segment. So let me turn it over to Jamil.
Hi, everyone. Thank you so much, Martha, for your leadership and for taking the care of this network with Jennifer and Jacob and Elizabeth. It's really very much appreciated how much the work that's done behind the scenes every day, and we really appreciate it. And on a personal level, I really want to recognize that, because I know how much work it's been just to do a CLE, even online. It takes a lot of time and work. So really pleased to have the network continue to sponsor CLE. We hope to be back in person at some point. And I also call on all the members who are participating today, and we have nearly 80 members or people on this call, to help us with this, as you will be hearing from us in the future. So with that, I just want to really quick update on the ICCPR review process. As Martha mentioned, I'm the director of the ACL Human Rights Program, and I also co-chair the ICCPR task force with the Asian American Advancing Justice Asian Law Caucus. This task force is actually a continuation of the work that was done over the last really 15 years or so. It started in 2006 with the last the review that happened two reviews ago, and continued with the U.S. Human Rights Network really creating a space and the organizing and the resources for coordination around treaty review processes, where we created these task force to help coordinate the process. Although the U.S. Human Rights Network is not anymore engaged or involved or active in this process, several organizations decided to continue to maintain the structures that we had, and the task force is one of them. So we are gearing up for the U.S. review in October. Most likely the review will happen in the middle of October during the October session of the Human Rights Committee. The U.S. government has held or will be holding up to 5 consultations. The last one will be on July 12th. And you can still RSVP for the last consultation. We will put in the chat right now an email where you can actually send your information so you can be added to the listserv of the ICCPR organizing. So you can get updates on what we're doing, what we're planning. There's at least 20 organizations that expressed interest in participating in the organizing of the review for the civil society groups in the United States. This is really fantastic. Appreciate their support. We encourage you to think about ways that you can use the review and the shadow reports, and we will be providing some ideas, some resources over the summer. The deadline for shadow reports will be September 12th. So you've got time to put that in. There will be a chance to brief the committee this summer during their July session, and you will get information about that if you happen to be in Geneva and if we manage to get a hybrid function. Really important at this moment in time, as Martha mentioned, when we are seeing attack on human rights framework, attack on very basic rights in the country, to really strengthen and to use these processes for organizing, for solidarity, for pushing back, and for accountability. So we don't have really many other things that we can do, at least using the international human rights framework or mechanisms. One of the few ways that the US engages is through the treaty review processes. And we hope that you will be joining us and continue to support this effort with other organizations. With that, I want to turn to our amazing speaker today, who is who I really have the honor to call her a friend and a colleague. So as you know, Meg has been active in the human rights space for many, many years and for decades. I was looking at her bio and trying to piece together what I'm going to say about her, because you can read the dry bio online, and it would be sharing it, and you probably got it in the part of the program. But one interesting thing that I didn't know, which now makes a lot of sense, that she has such a strong, before she went to law school, she had a lot of interest and continues to have, I'm sure, interest in literature. And that speaks to how a beautiful writer she is, and her and someone who worked with her or read her both scholarly work, and used it in some of the teaching, as well as co-counseling with her. I can see how that really been incorporated into her legal practice. Not only that she did that, she's such a incredibly humble and funny and intelligent and warm person to work with and to interact with. And she brings that not only to her teaching at NYU, where she is, as some of you know, she's a professor of clinical law since 2011. She is the director of Global Justice Clinic. She's also the faculty director of 2 other human rights centers. There's a lot that she does in a day job. But she also took the responsibility of being, or the nomination and the appointment of being, the UN Special Rapporteur on independence of judges and lawyers. And it most difficult time, I would say, of the judiciaries around the world and the human rights defenders who are lawyers, and protecting the bars around the world, and in fostering respect for human rights. So I don't think we would have had a better speaker than Meg to inspire us to hear from her what she thinks about what can be done and what can be achieved, and what we hope that would be a continued commitment that she has both to the US. She has worked in many countries, including the US, but just to mention few, in Guyana, Haiti, Kenya, Nigeria, Northern Ireland, Uganda, and of course in the United States. And she had litigated before the Inter-American Commission, as well as before the African Commission on human and people's rights. So she has extensive experience both in litigation and practice, as well as in academic work, and she's bringing that and she's sharing with us today. So with that, I want to turn it to Meg, and looking forward to hearing your keynote and taking questions afterwards. Meg?
Thank you so much, Jamil. That was rather hard to listen to. I really appreciate it. And Jamil, you're truly one of my human rights heroes, and it's been a real joy to work with you in so many different formats over the years. And I appreciate you underscoring how old I am by referring to the multiple decades that we've been doing this work. But I'll back at you, my friend. I also want to thank the organizers of the session, especially Martha Davis, Elizabeth Ennin, Jacob, who we've heard already is taking the bar, studying for the bar, and Jennifer as well, and all of you online today. So I'm going to talk a little bit about the mandate that I hold, and then also about some of the norms and human rights standards that are relevant here. But I just want to refer back, of course, to the theme, as Martha was saying, the rocky road to rights. And it's illustrated in the flyer for this event with an image of a hiking trail. And I want to note that the trail, I think, looks a lot more pleasant and easy to traverse than the path that a lot of us have had to tread in the course of advocating for human rights in the United States, where I would say at the moment, you might be encountering steeper climbs, slipperier slopes, and maybe even dangers not represented in the photo, like sinkholes, pouring rain, and any manner of dangerous pests. But as in hiking, we're always energized and buoyed by those who are accompanying us. And I think we all do know that at some point we will reach the top of that hill. And I also want to talk about the fact that there are guardrails that we might not see in that image. And some of those guardrails have to do with the mandate that I hold now that I'll be talking a bit about. So I've been asked to talk a little bit about the mandate. First, what I'm going to do there is give you a basic overview of kind of what my mandate is, and then I will leave the details to any questions you might have, since it could be, unfortunately, rather boring otherwise. But briefly, I will tell you a bit about the Special Procedures Program, which is a system, which is this terrible name for the part of the UN that my mandate is part of. I'll tell you a little bit about the substance of the mandate that I have, and then I'll tell you more about the importance of the independence of judges and lawyers, particularly in relation to the ICCPR, which is the theme. And then I'm going to address 3 specific threats to judicial independence and explain how I think those are particularly relevant to the United States. And then finally, I will touch on a couple of more positive thoughts around solutions. But before I proceed, I have to do this thing, which is to acknowledge that I have not visited the United States. Yes, that is true. So as a special mandate holder, I have to ask any country that I'd like to visit for an official invitation. And so what that means is I haven't been invited to the United States yet, even though, of course, I live there, I'm in Geneva right now, but I live there every day. But what that means is that I will be making comments about the US in my role as a US-based academic, because I haven't been able to come and officially investigate the status of judges and lawyers in the US. So briefly, what is a special rapporteur? We're commonly known as mandate holders, and we're independent experts appointed by the Human Rights Council. We don't represent governments, we're not nominated by governments, and we are totally independent and volunteers. We have a diverse array of titles, including special rapporteur, independent expert, and then there are a number of also working groups. And together these make up this large system. And right now there's 14 country-specific mandates and more than 40 thematic mandates. I'm not going to go into all of them, but just to give you a couple of ideas, judges and lawyers is one, torture, arbitrary detention, racism, the rights of Indigenous people, climate change, et cetera. The primary activities of mandate holders include kind of three main things. The first is to respond to complaints of human rights violations by engaging in something called a communications procedure, which is essentially a process where you can write to a mandate holder about a human rights violation, and then the mandate holder can engage with the relevant state or non-state actor about those violations. And I'd be happy to talk more about that in the Q&A, because it's actually one of the processes that US advocates can engage in with any of the mandate holders. Second, we undertake these official country visits, which I've already mentioned. Once we're officially invited, we visit, we engage directly with rights holders, with government, with non-state actors who are relevant to human rights, and then we report back to the Human Rights Council and to the General Assembly. And third, we prepare thematic reports. So we can write on any theme that we see as within our mandate, and we can focus on both the challenges facing folks under that mandate, and then also good practices. So what's the theory of change governing the work of special rapporteurs and other mandate holders? I think it depends a lot on the mandate, but generally speaking, special procedures have soft power. So our work has impact through promoting public awareness of human rights violations, bringing specific attention to particular cases, bringing attention to themes and trends in how violations are happening in non-state violators, and then also documenting particular human rights situation over time so that we can talk about these trends and ways to change the negative and advance the positive. We also can engage in kind of what I might call good offices. So we can offer technical advice for governments or other actors who are trying to implement human rights obligations. And then through thematic reports, we can offer, actually, I'm not going to say we here. Other thematic mandates have offered influential interpretations of the issues and law applicable to their mandates, and they've been referred to in the judgments of national, regional courts, international courts, and by academics. So those of you who like to think about kind of the sources of international law know that if we use things that mandate holders write, you can sort of help turn those things into binding law eventually through customary law or through interpretation of treaties. So special rapporteurs have contributed to the development of international standards. You're probably familiar with the John Ruggie principles, the UN guiding principles on business and human rights, which he created through his mandate. And those have become really the global standard for corporate human rights obligations. Similarly, and this is something I know that Jamil was involved in, the former special rapporteur on torture, Juan Mendez, spearheaded the creation of the Mendez principles on effective interviewing for investigations and information gathering. And I'm sure many others of you have been involved in that as well. And that those have been very important, I think, since they were released. And that's really crucial because in many ways, human rights advocates and social movements are the ones who make real the potential power of any mandate holder. Activists and movements really breathe life into the work of special rapporteurs or working groups and help to shift the discussion and advance a human rights approach to essential issues. And here I really want to lift up the work of former special rapporteur Tendai Achiume, who reported on contemporary forms of racism. You know, her focus on reparations for racism rooted in colonialism and enslavement highlighted the need for structural solutions and the transformation of the international order. And I think it's been incredibly influential. Also, I want to mention my colleague, Philip Alston, who in his former role as special rapporteur on extreme poverty, really talked a lot about how private companies who were at that point really being forwarded as a crucial partner for realizing human rights, that there is, through the profit motive, often a really strong pull in the opposite direction, especially for people who are living in conditions of poverty. So I'm speaking to you from Geneva, and I won't go into this more, but it's the only time during the year when we all meet together as mandate holders and try to talk about how to work together and cooperate. And I'd be happy to answer any questions you might have on that. I just assumed this role on November 1st for an initial 3-year term. And the scope of this mandate which was set out in one of the older mandate resolutions in 1994, is to identify and record attacks on the independence of the judiciary, lawyers and court officials, and progress achieved in protecting and enhancing their independence. So it's tasked really with looking at those dynamics and then making specific recommendations for how to improve judicial and legal systems. So how does that relate to the ICCPR then? First, the rights within the scope of my mandate are specifically protected by the ICCPR. Article 14 guarantees the right to a fair and public hearing by an independent and impartial tribunal established by law in the determination of any criminal charge and any rights and obligations in a suit at law. To give effect to that right, the independence and impartiality of the tribunal's decision makers must be secured. In General Comment 32, the Human Rights Committee, which is the treaty body, as you know, tasked with the monitoring and implementation of the ICCPR, clarified that the requirement of competence, independence, and impartiality of a tribunal is an absolute right, not subject to any exception, and that states must take specific measures to guarantee the independence of the judiciary. Article 14 specifically requires that a tribunal must be both independent and impartial, and the committee has further articulated and clarified the separate weight of each of those pieces. Independence refers to the procedure and qualifications for appointing judges, guarantees relating to their security of tenure, and conditions governing promotion, transfer, suspension, and cessation of their functions. Independence also concerns the actual independence of the judiciary from political interference by the executive and the legislative branches of government. Impartiality requires judges to ensure their judgments are not influenced by personal bias or prejudice, and that they don't improperly promote the interests of one party to the detriment of another. Importantly, and I think we've heard a lot of discussion about this recently, but I think it bears underscoring that courts have to not only avoid partiality, but they have to avoid the appearance of partiality. Article 14 of the ICCPR also includes provisions relevant to lawyers, requiring states to guarantee legal assistance for those accused of a criminal offense. Those guarantees of access to counsel encompass the right to choose one's lawyer, the right to free legal assistance when the interests of justice require and defendants don't have sufficient means to pay for one, and also they require certain forms of access. Various international legal instruments stress the importance of independent lawyers associations also in guaranteeing the free exercise of the legal profession, including the involvement of lawyers in protecting the rights that are enshrined in Article 14. The Human Rights Committees clarified that lawyers must be able to advise and represent persons charged with a criminal offense without restrictions, influence, pressure, or undue interference from any quarter. In order to protect those interests, particularly that their capacity to represent their clients without harassment, bar associations must be able to operate independently, free of influence from the executive or any other power. So the ICCPR makes specific provision relating to the protection of judicial independence and the provision of legal counsel in certain circumstances. But the reasons for guaranteeing the independence of judges and lawyers extend far beyond the limited formulation of Article 14. The principle of judicial independence is really the bedrock foundation on which all other rights enshrined in the ICCPR rest. And that's really the case for two reasons. First, a strong, impartial, and independent legal system plays a central role in guaranteeing individual rights. That's true of all protected rights, civil, political, social, economic, and cultural, not just the ones enumerated in Article 14. In recent years, human rights scholarship has tended to shift away from a focus on judicial enforcement of rights, which I think is entirely appropriate because there's a real corpus now that has established justiciability. And also because determining whether rights are effective involves far more than asking whether they're justiciable. Rights are potent at least in part because they're a rallying point for social movements and grassroots activists, because they act as a framework for policy, legislation, and the activities of companies, and because they empower individuals and communities to demand what they're due as a matter of right, not discretion. But in acknowledging the power of rights as a political and organizing tool, it's important not to turn our attention away from the importance of the law as law. Judicial enforcement of rights remains important for so many reasons, because such enforcement helps to articulate and develop the jurisprudence of rights, because enforcement can lead to reparations for those impacted by rights violations, and because enforcement moves rights claims from the theoretical to the concrete, demonstrating the power of individual and community rights against the might of states, companies, and other powerful actors. Judges who are not independent cannot uphold rights claims without fear or favor. A judge who fears dismissal or harassment by the government will struggle to find that the state committed acts of torture, that their arrest and harassment of those who protest against the government is a violation of the right of peaceful assembly. Judges who are partial can't constitute a bulwark against discrimination. A judge who believes that people from racialized groups have a higher propensity to commit crimes or that women should not work outside the home will obviously be less likely to uphold a claim for arbitrary arrest and detention on racialized grounds or a claim for workplace sexual discrimination. And judges' professional backgrounds may also have an impact on their independence and their ability to uphold rights claims. If, for example, the majority of judges are former prosecutors, a pro-prosecution bias may shape their individual decisions and influence the wider trajectory of criminal jurisprudence, meaning that defendants in criminal cases are more likely to find the deck stacked against them. Independence and impartiality are a requirement of a good quality justice system, which is an essential component of access to justice, which in turn is essential for realizing protected rights. The Indian jurist, politician, and diplomat Lakshmi Malsinghi put it succinctly in 1985 when he was tasked by the then Subcommission on the Prevention and Discrimination and Protection of Minorities with the preparation of various reports on the independence of judges and lawyers, which played a foundational role in the creation of this mandate. He said, quote, "It needs to be stressed that impartiality and independence of the judiciary is more a human right of the consumers of justice than a privilege of the judiciary for its own sake." And I think that's absolutely crucial to remember today. But the importance of these principles goes beyond enforcement of individual rights, which brings me my second reason for stressing the independence of judges as vital to the realization of the rights enshrined in the ICCPR, which is that the independent and impartial legal system is a key pillar of a democratic system of government. The judiciary is one of the key institutions that guards the health of a democracy. Independent judges guarantee the same laws are applied to everyone and ensure that nobody is above the law, whatever their level of wealth, power, or political status, that no one is outside of the law, whatever their status, and that no one is under the law. They ensure that society is governed on the basis of predictable laws rather than the will of an autocrat. An autocratic system of government poses a potential threat to the life of all rights enshrined in the ICCPR. If there's no effective check on the might of the state, governments are free to subject their opponents to surveillance, harassment, arbitrary detention, even torture, to impose curfews and restrictions on citizens' movements, to discriminate against disfavored groups, to restrict freedom of religion, belief, and expression. In short, to systematically violate any and all of the rights protected by the ICCPR. This makes it all the more alarming that we're living in an age of rising authoritarianism and democratic backsliding, in which the rule of law is increasingly coming under threat. The World Justice Project reported that 2022 was the 5th year in a row that the rule of law declined in most countries around the world, with checks on government power falling in 58% of countries and respect for core human rights and freedom falling in 2/3. Protecting the independence and impartiality of the judiciary is a vital means of shoring up rights promoting systems, as well as ensuring individual claims receive a fair hearing. So I'm focusing on judicial independence today, but I note briefly that everything I've said is applicable to the independence of lawyers. For individual rights claims to be effective and the broader justice ecosystem to check the power of the state, claims must actually be brought before independent courts, which necessitates the existence of a community of lawyers and allied legal professionals who are able to exercise their profession without restriction, fear, or harassment. They must be free to represent clients from all walks of life, including members of racially, ethnically, nationally, religiously, or otherwise marginalized groups, and to make every argument that's properly available to them, constrained only by the rules of the court and their professional ethical obligations. So these are the reasons why the independence of judges and lawyers is relevant to protecting and promoting the rights enshrined in the ICCPR. Given the centrality of independent judges to the realization of these rights, what threats to judicial independence should human rights lawyers be alert to? I want to just address briefly 3 key threats to the functioning of a healthy, independent, and impartial legal system. So I've already touched on the first of those, which is the growing threat of direct threats to the independence of the judiciary by political actors as part of a process of intentional autocratization. The second threat I want to address is the capture of the judiciary by elites and wealthy corporations. And finally, I want to examine briefly the continued existence of systematic inequalities in the composition of the judiciary. So beginning with the threat of autocratization, there are 2 particular ways authoritarian governments attempt to capture, undermine, and neutralize judges: by undermining systemic controls that ensure the separation of powers, and by harassing and attacking the credibility of judges and the justice system. Autocrats erode the separation of powers in an attempt to make judges of one mind with the government so that they won't restrict or challenge the exercise of its authority. One way that may be accomplished is by introducing new limits on the power of courts to review the legality of executive or legislative action. Governments may also improperly assume control over disciplining judges, either indirectly by influencing bodies responsible for that kind of discipline, or directly by seizing the power to sanction and remove judges from office, or by threatening impeachment against judges for reasons relating to their politics. Judges may then be removed arbitrarily for no apparent cause or in order to further specific political goals. In support of the decision to remove them, judges may be subject to vague accusations substantiated by minimal evidence. Reasons cited in favor of removal may include allegations that judges are politically motivated or that they are biased in favor of certain parties that appear before them simply because they belong to the same racialized or subordinated group. While it's necessary to guard against impartiality and the politicization of judges in order to ensure judicial independence, this is a convenient excuse that appeals to populist narratives of a distrust in the system, racist tropes, and the need to, quote, drain the swamp. Additionally, judicial independence may be undermined through changes presented as reforms to the nature or composition of courts. Political actors may take increased control of judicial appointments and promotion. They may alter the rules or processes around selection in ways that diminish the focus on judges' professional qualities and personal temperament and increase the importance of their political affiliation. Other steps that may have the effect of eroding the separation of powers include altering judicial term lengths when those exist, or introducing or changing a mandatory or age of retirement in a way that politicizes judicial service. It's important to note that countries enjoy a wide discretion in constitutional models, including the structure and composition of their courts. Court reform can be pursued for wholly legitimate aims, but reform processes must not have a negative impact on the independence of the judiciary. In addition to undermining independence by eroding the separation of powers, political leaders may discredit, harass, or attack judges so that they fear to make decisions that will attract the ire of political leaders. And when they do, they may not be trusted or supported by the population. In General Comment 32, the Human Rights Committee made clear that states must protect judges against intimidation. But in countries around the world, we see that judges are subject to severe threats and actual attacks, both in person, through criminalization, and also online. As many states fail to provide adequate protection for judges or accountability for perpetrators of attacks, we see also instances in which government officials are the very source of the harassment. Government officials can undermine judges' credibility and status by making public statements that sound in discourses of racism, sexism, or other forms of bias. Abuse of this kind often decries judges as elite, out of touch, failing to respond to the will of the people, particularly when they take decisions that check the power of political branches. Of course, judges are not perfect, and it's vital that states do not punish or censor legitimate criticism of public officials, including judges, and of course, judicial decisions. But judges should benefit from the general protection afforded to all citizens, not to be harassed, defamed, or otherwise attacked. Such attacks have the effect of intimidating judges from acting with due impartiality, particularly in cases involving the government or their supporters. When we think about the risk of undermining judicial independence, the first focus is often on the kind of threats I've just described, and in particular on ensuring that other branches of government don't influence the outcome of judicial decision-making. But those are not the only interests that can impact the independence of the judiciary. Individuals and businesses with significant economic power and status can also seek to influence judges to obtain favorable outcomes, which brings me to my second threat, the problem of economic capture. This problem is not limited, but certainly plainly includes quid pro quo corruption, or even the provision of gifts, favors, jobs, or other benefits in kind, with the type of tacit hope and perhaps not an explicit agreement that better treatment will result, or that a judge will be enculturated into a certain way of thinking. In the United States, such risks are generally managed through disclosure rules, which require judicial transparency concerning the receipt of particular benefits in order to mitigate the risk, not only of actual bias, but also of the appearance of bias. Such rules are essential and must be upheld. But beyond sitting judges, economic capture may also impact the selection of judges, particularly when money plays a part in judicial election campaigns. International law recognizes a wide variety of systems for the selection and appointment of judges worldwide, including appointment by popular election. And in the United States, as we know, elections play a part in determining which judges sit on the highest courts in more than half of US states. This could be through partisan elections, nonpartisan elections, or retention elections where voters decide whether to keep judges on the bench or not. And the position is comparable in intermediate appellate courts and trial courts. These elections attract big money in the United States. Funding may come from political parties, interest groups, or individuals, and may be provided to support candidates in their election campaigning or used to finance ads or events. In many states, campaign finance laws limit the amount that can be spent on each judicial candidate and require campaigns to disclose spending by donors that exceeds particular sums. But such laws may not capture all forms of spending, in particular, indirect spending by interest groups to support candidates, and some states do not have contribution limits at all. Recent cycles for election to state Supreme Courts have been more expensive than ever, with spending reaching close to $100 million. It's possible that spending on judicial election campaigns could constitute an inappropriate, sometimes systemic effort to unduly influence judges. Such spending may amount to an attempt to influence the decisions made by individual judges or to shape the nature and composition of the judiciary overall, to create an environment that's more conducive to donor aims. That's the particular kind of capture I'm going to turn to now. The judiciary must guarantee that everyone's equal before the law, but where wealthy individuals and big money play an outsized role in the selection of judges, it may be the case that some people or some interests are more equal than others. A 2018 study by the Brennan Center offers a summary of research on the impact of election spending on judicial decision-making in state Supreme Courts in the US. A 2001 survey of state court judges revealed 46% of those judges themselves believed that campaign contributions had at least some impact on decisions. Other studies reinforce this view, demonstrating a correlation between election contributions from business groups and pro-business outcomes, and a correlation between spending by political parties and favorable outcomes for those parties in election law cases. These correlations essentially disappeared when judges were serving their last term before mandatory retirement, suggesting that judges were influenced by the need to please donors and obtain funding for their reelection. Even if election spending didn't have an actual impact on judicial decisions, the impression of negative impact can be tremendously damaging to public perception of judicial impartiality. A massive 90% of respondents to a national poll conducted in 2013 by the Brennan Center said they believe campaign cash affects judicial decisions. Of course, one solution to this loss of public confidence is for judges to recuse themselves from decisions in which they have a conflict. However, it's in the case of interest group spending in particular, recusal may not be straightforward. The identity of donors may not be disclosed, or recusal rules may not require judges to step aside when hearing cases involving individuals or groups who provided indirect donations via interest groups. It's also vital that in the selection of judges, there should be no discrimination against candidates on any grounds protected by human rights law, such as race, color, sex, language, religion, political or other opinion, national social origin, property, birth, disability, sexual orientation, gender identity, or other status. And that last point brings me to the final threat to judicial independence that I want to discuss today briefly, which is the need to combat the effects of systemic discrimination in the judiciary. The judiciary should reflect the society it serves because equal participation in public institutions is a fundamental human right. Where public institutions are not broadly representative of groups within a given society, it suggests this right is not being protected. But judicial diversity is also a vital factor in shoring up the legitimacy of legal systems. In recent years, these systems have been challenged rightly for their failures to deliver on everyday justice needs of ordinary people. Mass movements from Black Lives Matter to responses to the climate crisis and beyond are demanding more of institutions that have done too little to address systemic racism, growing inequality, environmental destruction, and other injustices, as well as processes that ensure the judiciary is protected from political influence or elite capture. Judicial independence requires individual judges to be free from bias and discrimination. To maintain their confidence in the legal system, people have to feel satisfied that their case will be treated fairly. This is not cosmetic. Diversity in judges' life experience impacts their approach to legal problems and enriches their jurisprudence. For courts to play a nuanced role in dismantling systemic discrimination, decision makers should have expertise on being on the subordinated end of such harms. So how does the US shape up in terms of judicial diversity? I'm going to turn again to some Brennan Center data concerning diversity in US state Supreme Courts. As of May 15th, 2023, the statistics are not encouraging. In 18 states on that date, no justice is identified as a person of color, including in 12 states where persons of color make up at least 20% of the population. Across high courts in all 50 states and Washington, D.C., just 20% of state Supreme Court seats were held by people of color. By contrast, people of color make up over 40% of the US population. Men held 58% of high court seats. And in 6 states, there was only 1 woman on the Supreme Court bench. It's clear that more needs to be done, both to correct the effects of systemic discrimination on the judiciary and to shine a light on groups whose representation in the judiciary is currently overlooked with data collection efforts like LGBTQ judges, judges with disabilities, and judges from immigrant backgrounds. So turning to my concluding portion, I want to think a little bit about positive solutions. The first solution is, of course, to remain vigilant to threats and respond to them, and to recognize that there are human rights norms that are relevant to these issues. I think sometimes we're not aware of those, just like invisible guardrails, but we've got to know that they're there and be able to use them. In my role as special rapporteur, I'm committed to ensuring concerns about attacks on individual judges are brought to the attention of governments and the international community, and to identifying trends and systemic forms of attack. Governments have to prioritize the collection and publication of disaggregated data, and they have to take additional positive steps. Many actors who want to undermine judicial independence have claimed an alignment with the people against elite judges. As advocates for the rule of law, we have to look for ways to counter this narrative. Of course, the problem is there's some truth in the argument that conventional legal systems can be remote, alienating, and inaccessible. If we want the rule of law to remain a sufficiently potent force to protect democracy, we must democratize the rule of law. And that involves ensuring legal principles are understandable, effective, and potent, and that legal systems offer solutions to justice problems that people encounter in their daily lives. Deep inequalities often match with exposure to legal problems. Those who experience discrimination, exclusion, or marginalization are often more likely to experience unmet legal needs. In the United States, a national survey found that low-income Americans were unable to resolve a shocking 92% of their justice problems. Even when the supply of lawyers is relatively plentiful, this doesn't translate into adequate availability of legal services. In the US, most low-income people don't even bother to seek legal help, with more than half saying they don't know if they could find or afford a lawyer if they needed one. And that's despite 74% of low-income households experience one or more civil legal problems in the past year alone, with 39% experiencing more than 5 such problems. One way the rule of law and legal systems can be brought closer to the people is by ensuring that lawyers work to make their services available for all, including those who are most marginalized and least able to pay. For some individuals and groups, gaining meaningful access to justice might also involve support from legal representatives who work closely with communities in order to respond to the issues they face. Legal systems have been slow to recognize the expertise of grassroots activists, jailhouse lawyers, community paralegals, and other trained non-lawyer justice advocates. But rigorous, high-quality, critical legal empowerment is possible. In this connection, I welcome the work some states have done to create space for what they call allied legal professionals, trained legal practitioners who don't have law degrees, by authorizing those providers to offer legal advice in certain case types and under certain circumstances. Much remains to be done. Reform of unauthorized practice of law rules is badly needed to ensure those who have real skills and capacity can serve their communities. An excellent example here is that jailhouse lawyers, who often have years of successful experience advising their peers when they're on the inside, often return to their communities without the right to provide even the most modest forms of legal advice. In closing, I want to return to the theme of this symposium. The road to rights is rocky because of a variety of impediments, which will no doubt be addressed ably by the rest of this program today. A tough path can be made less dangerous by an independent judiciary, like invisible guardrails, independent and impartial tribunals, coupled with access to justice, ensure the path is passable for all. The lessons of legal empowerment are valuable for all of us who want to resist attacks on judicial independence and reinvigorate the rule of law. As Vivek Maru, the founder of Namati, has said, law and government should be palpable earth in people's hands, not abstractions sealed in books or courtrooms. With such earth in everyone's hands, judicial independence will become a core value recognized as a human rights norm. And in this way, we can bring human rights home to everyone. Thank you.
Thank you. This is the first CLE code announcement, LN43H1. LN43H1. Thank you.
Thank you so much, Meg. This was also the code to say how amazing you're an uplifting, even though it's a very difficult. But I love the ending with democratize the rule of law and really emphasizing what needs to be done across the board, and particularly your comments very relevant and timely to what's happening in the United States. So we have a few questions already in the chat that I'm going to start getting to you. First one is the Bangalore says the Bangalore principles have never been cited by U.S. court, and international law is only rarely recognized. How does the judicial isolation from international standards affect the U.S. legal system? We can take one by one, or I can read a couple more. It's up to you. How do you prefer?
If you have a bunch, why don't you get a couple more?
Okay, so
if you don't, we can go with that one. It's a good one.
Yeah, so there's another, it is a really interesting comment by Rob Robinson, who I'm sure you know, and as many of you know, he's, talks about the way that there is much more interest in communities than ever about the human rights framework. And he's asking, and he's sharing some of the experiences, a really powerful experience that he had engaging with UN experts and rapporteurs. Would you be interested in unofficial missions to the U.S.? Given that there were some that happened over the years, and so that's really great. Thank you, Rob, for that question. And then there's another question from Alina Carnillo. She'd like to, or they'd like to know if the mandate, your mandate, includes a focus on countries' respect for decisions by judges in other countries. For example, she's thinking about Ecuadorian Judge Alberto Guerrera in the case against Chevron, which got a lot of attention, obviously. So let's take those and then we'll come back to the chat. Meg?
Those are great. Yeah, those are fantastic questions. Thank you so much. So the first question about the Bangalore principles, and I'm really glad that you mentioned those in the question, because a lot of us don't know about these principles, but these are principles on judicial independence that are internationally accepted, very authoritative principles that can be really helpful. And I would commend them to you as really human rights principles. And it's true, excuse me, our judges don't tend to know about them. And I've started to talk to US judges more about these. And so I think that you're right. It was through your question, you talk about judicial isolation. US judges do tend to be significantly more isolated than judges in a lot of other places. And I've just started to see that very concretely by talking with judges in a lot of other countries. So yes, I think that our isolation and our US exceptionalism that I'm sure you all are all too familiar with has a direct impact on these issues. And I think we can start citing to these, at least in footnotes, and as potential persuasive authority when talking about some of these issues. The second question was about unofficial missions. And yes, I think I know exactly the unofficial mission you're talking about. That was Katerina de Albuquerque and Leila Farhani. I'm getting her name wrong and I apologize. Jamil? Leila Farhani, that was it.
Leilani Farha.
Leilani Farha, thank you so much. So I really apologize for that, but that was such a powerful mission. And I know that they also did some amicus work around the Detroit situation. So yes, I am very much open to that form of unofficial mission and to that kind of collaboration. So please feel free to reach out to me. And then I think the final question was about, yeah, this is a great one. So about US respect for decisions made in other legal systems. I think what I want to say here is that this is another place where we can be citing to international principles. So if you think about interstitial kind of norms around comity and norms of interpretation that US judges have to use when making this kind of decision, using international standards to evaluate a judicial system is a very good way of doing it objectively. Because we can see, and I'm not going to comment on this particular case, but we can see in a lot of US decisions that there are certain kind of folk ideas about other systems, and they're often based on a lack of knowledge. And so I think really using these more objective standards that are based in human rights can be very helpful in that effort as well.
Hey, thank you, Meg. So there's a quick question from Cindy Cindy Suhu from CUNY Law. She says, I strongly agree that we must do more to support the role of judges and judicial independence. But what should activists do when confronted with activist judges who do not appear to be committed to the rule of law or precedent? How can we critique and reform judicial system?
Such a timely question.
Yeah, I want to add
Yes.
another question, if you don't mind, since I don't have anything in the
Please.
queue. One is about the prosecutors.
Yeah.
They are lawyers and they're
Yep.
working in a system. And before anything goes to the judges, this is where things, or government lawyers in general, the ones who advise the government on the law. And we know how harmful this role could be and devastating for the lives of people, particularly the ones who don't have the means to defend themselves. Or the ones that you mentioned in your presentation. How is your mandate? How do you perceive that sort of a kind of way of dealing with these kind of situations? Because we are seeing more in the US, of course, a healthy debate about the role of prosecutors and what needs to be happening with regard to their not only just independence, but really their ethical responsibility toward the profession and the people that they are supposed to protect and serve.
Great. So I love both of these questions. And I think Cindy's question really goes to this idea of, can a judge be too independent? And I think it's kind of a nice way of asking it, but I think the answer to that is judicial integrity. And if you look at the Bangalore principles, for example, you'll see that judges are, of course, not only required to be independent, but they also are meant to and must decide their cases on the basis of established law. and on the basis of human rights and other principles. So I think that in particular in the US right now, it's perhaps very helpful for us to be talking about integrity. And I think that looking at and giving substance to what integrity is about, which is really about ensuring that law is being fully complied with, and as we are all used to doing, talking about the need to interpret law to advance the rights of human beings. So I think that's important. How to critique and reform judicial system, I think, again, is to say, like, look, there are human rights norms around this. This is not just an abstract theory of democracy, but there actually are things that we can look to that say, here's how you can go about reforming legal systems. Here's how you can go about reforming judicial systems without throwing away the core bedrock principles that need to be protected. In terms of the role of the prosecution, I'm really glad you asked that, Jamil, because I didn't talk about that at all really today, except to say that sometimes there are pro-prosecution bias in judges, and there's some really interesting empirical work on that in the US that I've read as a scholar and that I would commend. I think that there's, again, a lot to be said about some of the bedrock principles that apply to prosecutors. There are also some international norms there. One of them is that prosecutors always have to look at the option for alternatives to prosecution. And so if that's a background rule, it should have then a whole lot of really fulsome grounding and practice. So both substance behind it and then also practices within prosecutorial services. And so that's something actually I'm really excited to potentially look at as a thematic issue, is to kind of look at what does it mean to really reimagine the role of the prosecutor as, again, what they're supposed to do in every system, which is uphold justice and to uphold human rights. They don't check that at the door and simply, they're not simply trying to ensure prosecution, but actually to think about what does justice mean? And some of the amazing work that I think that's been done in the US on restorative justice, and some thinkers in this space, I think could be really helpfully brought into conversation with international thoughts on this as well.
Great. I think we have one last quick question by Eric Crew from the Haitian Bridge Alliance, and it's really important one. We will have a panel to talk about that, but I really love your take very quickly, which is, what about the immigration lawyers,
Yes.
Immigration judges or immigration
Yes.
system that is within the executive branch? How does that
Yes.
really meet international standards of impartiality, independence, and so forth? Appreciate that quick comment on that.
Such a great question, and thank you very much, Haitian Bridge Alliance, you guys are doing such important work. So I will say for sure that is an issue I'm extremely interested in, and it's an issue where there needs to be a lot more work. So if you look at as we know, if you look at the requirements under international law for how individuals should be able to claim asylum, should be able to have due process in that process, have due process if they are facing deportation or expulsion, there's a lot to say about the lack of protections there. But one of them certainly is whether there is an ability to seek independent judicial review of these decisions. And I will have a lot more to say about that at some point, but I think it's a crucial question, and it's one that's really important around the world, but especially right now in the US. So thanks for bringing it up.
Great. Thank you so much, Meg. Unfortunately, we have to wrap it up because of time. It's been incredibly amazing to hear from you and to have you as a special rapporteur. I'm sure we will be hearing more from you. We want to engage with you. So if there was a function on chat of like not just a clapping or standing ovation, we should have used but really,
that's very kind. Thank you so much.
Yeah, and I want to just share before we transition back to Martha, just to share, I have to jump off to go and celebrate with my colleagues. Really great, amazing news, not just the Supreme Court decision, but now that we have 2 ACLU colleagues got confirmed for federal judges. So Dale Ho, our Director of Voting Rights Project at the ACLU, and News Chudori. Both have been confirmed by the Senate as federal judges. So here's some good news, and people who would be defending rights of people be really independent and truly committed to social justice and human rights. So with that, I want to turn it back to Martha.
Thank you.
Thank
Great
you.
news. Thank you. Thanks, Jamil. Thanks, Professor Satterthwaite, Meg, for sharing your insights with us. I, in my youth, was a hiking guide, and you didn't mention the importance of guides, but I think that's the role that you and Jamil have played today for us, so I really appreciate it. So on that note, I want to transition us to our first panel titled The Courts and U.S. Compliance with Treaty Obligations. So it follows very, very nicely on what we've just been talking about. As many of the folks on this webinar will appreciate, there have been a number of high-profile cases in recent years where the Supreme Court and other courts have taken the U.S. in what we would say is a wrong direction and retrogressing on human rights. And this is a challenge for U.S. civil society. And frankly, it's also sometimes a challenge for a human rights respecting administration, which can't easily overcome constitutional rulings. And with that in mind, we put together a panel of experts to discuss the challenges of working with this system and who've given thought to the ways to use human rights mechanisms to respond to these challenges. And to moderate this panel, I'm happy to introduce Professor Cynthia Suhu, a longtime U.S. human rights advocate. She's professor of law and co-director of the Human Rights and Gender Justice Project at the City of New York School of Law. So I'll call you Cindy. Cindy, I'll turn it over to you.
Thanks so much, Martha, and thanks so much to Meg. I feel like that was such a great start and a tough act to follow, but I think we have an amazing panel, so I feel like we're up for it. I want to thank Martha and the staff at Northeastern for hosting us, and also just to say that I'm really excited to be moderating this panel. I think it's really important and timely for us to be thinking again about U.S. treaty obligations and the roles that the role that the courts can play in helping us comply or perhaps bringing us further away from meeting our human rights obligations. And we have really a fabulous group of speakers who are talking really, I think, about some of the most critical issues of our time. So I'm not going to take any more time at the beginning, but I'm just going to do a brief introduction of all the panelists. And then I've got 2 questions that I'm going to raise, and people should feel free as we're talking to drop questions in the chat, because hopefully we'll have time after the initial 2 questions to answer those questions. So just in terms of a brief introduction, with us today, we have Pilar Herrero, who is a senior staff attorney in the U.S. Human Rights team at the Center for Reproductive Rights. Miriam Jordan, who is a climate justice attorney at Earth Rights International. Thanks for the wave. Patty Ferguson-Boni, who is a professor and faculty director of the Indian Legal Program at the Sandra Day O'Connor College of Law at Arizona State University. And Ian Kiesel, who is a professor at Cornell Law School and founder and director of the Transnational Disputes Clinic and Migrants' Rights Initiative. So really excited to be here with you all. So the first question is, in your respective areas, how does U.S. law and policy fall short of meeting human rights standards and U.S. treaty obligations? And what has been the impact of recent Supreme Court decisions? So I'm going to start it off with Pilar.
Thanks, Cindy. I'm starting my timer, so you're going to keep me honest, and my clock is too. So unfortunately, U.S. law and policy on reproductive rights falls short of human rights standards in many ways. For example, many people in this country have been without access to abortion for a long time due to economic barriers, stigma, a limited number of abortion providers who face constant threats and harassment, and legal restrictions that have been escalating for years. When we consider maternal health, many pregnant people have limited options when it comes to where, how, and with whom they give birth. The U.S. has the highest rate of maternal mortality and morbidity among wealthy countries, and disproportionately high rates of maternal death among Black and Indigenous people. Our healthcare system is undermined constantly by biased and disrespectful care, discrimination, and lack of meaningful informed consent. Many people lack comprehensive sexuality education. Our child welfare practices target and separate low-income families and families of color. And the list goes on. So US constitutional law in the area of reproductive rights has focused heavily on themes of liberty and privacy. These rights are important, and CRR has a publication on Roe and intersectional liberty doctrine that discusses a range of intertwined constitutional protections that people of many different backgrounds rely on, including advocates of LGBTQ rights. US constitutional law has explicitly addressed abortion and contraception and gave some room for lawyers to imagine how the right to make decisions about pregnancy might one day be applied to other situations. But there were so many aspects of reproductive health that were not explicitly addressed, and many people whose rights were not protected in practice by those decisions. And there are also so many other ways of thinking about reproductive rights that have not yet been utilized or validated in US courts. Many reproductive rights advocates have found that, in general, the international human rights law framework provides more opportunities to explore intersectional discrimination, make connections between rights, and apply rights in diverse factual contexts when compared to our domestic law. International human rights law includes protections for a range of rights that are implicated in reproductive health, including fundamental rights to privacy, life, health, equality and non-discrimination, bodily autonomy, and freedom from torture and cruel, inhuman, and degrading treatment. If we think expansively about sexual and reproductive health and rights, we can identify instances where the right to information, expression and belief, cultural rights, family rights, the right to movement, to enjoy the benefits of scientific progress, and other human rights might also be implicated. Reproductive rights violations have been recognized by UN bodies and human rights experts for many years, including the Human Rights Committee, the Committee on the Elimination of Racial Discrimination, the Committee Against Torture, the Committee on Economic, Social, and Cultural Rights, the Committee on the Elimination of Discrimination Against Women, and the Committee on the Rights of Persons with Disabilities, and the Committee on the Rights of the Child. And UN human rights experts and bodies have also issued statements specifically about the US. As recently as this month, UN human rights experts issued a press release urging the US to ensure access to safe and legal abortion. So US law and policy has never adequately protected reproductive rights, and yet the gap between US law and international human rights standards is growing. This is because international human rights law is developing, but also because the US is rolling back rights, contrary to human rights principles of non-retrogression. Nearly everyone here is likely aware of the SCOTUS decision in Dobbs v. Jackson Women's Health Organization, which was issued nearly a year ago and overturned 50 years of precedent by taking away the constitutional right to abortion. The decision opened the door for states to ban abortion outright, and many of them have done so. On our website, the center maintains a map of state abortion laws called After Roe Fell, and it gives you a picture of how far out of reach abortion care is for people in some parts of our country. Over a dozen states currently ban abortion, with some including both civil and criminal penalties. Others are moving in that direction. From a public awareness standpoint, many people have a much better understanding that their human rights are being violated post-Dobbs. But while the Dobbs decision made the assault on reproductive rights much more clear, there's still plenty to be confused about. The Dobbs decision unleashed legal chaos and confusion among courts, healthcare providers, pregnant people, and the community members who love and support them. In some states, there are multiple laws restricting or banning abortion, and it's difficult for anyone to interpret or harmonize them. In states where there are exceptions, for instance, for rape or for the life or health of the pregnant person, it's proving very difficult for anyone to understand their risks and rights. Providers are caught between their duty to provide quality care to patients and the risk that they might face fines, jail time, and loss of their professional license for doing so. In a lawsuit the center filed this year against the state of Texas, doctors and patients described the pain and suffering they've endured because of the state's abortion ban. For example, a patient plaintiff named Kirsten went to a hospital after her water broke and was told to wait until she got sicker or went into labor, and that if she tried to leave, she could be arrested for trying to kill her baby. Kylie was forced to carry a pregnancy to term, knowing her baby would die shortly after birth and that a cesarean section would be necessary because of the fetal diagnosis. Amanda became septic and spent 3 days in the ICU after her water broke too early and she was denied timely abortion care, which was the standard of care in her situation. Texas has an emergent medical condition exception, but these women's experiences make clear that the state is risking the lives and health of pregnant people. And for every instance where someone is denied abortion care in an emergency, there are many individuals who simply decide that abortion is right for them but then face impossible barriers to acting on that decision. By targeting people who seek essential healthcare, people who provide it, and helpers too, abortion bans are isolating pregnant people, cultivating a climate of fear and avoidance around reproductive health, and having a chilling effect on the networks that pregnant people rely on for information and support. Laws that criminalize abortion normalize the idea that pregnant people's most fundamental rights can be modified or suspended, and they extend the reach of a criminal justice system that is already notorious for discrimination against communities of color. The criminalization of reproductive health also amplifies concerns about the way that healthcare sites can facilitate surveillance and control, making it difficult for marginalized communities to access quality care and trust healthcare providers who might ultimately police and punish them. And finally, the gap between US law and international human rights law is not only growing, it is also intensely contested. International and comparative law has been used by abortion opponents to argue that US laws are too permissive when compared with other countries. This claim is a misleading oversimplification. A rigorous review of comparative laws on abortion reveals that the Dobbs decision put the US out of step with comparable jurisdictions, and that the global trend has been to expand access. Similarly, there's an ongoing effort to attack the inclusion and legitimacy of sexual and reproductive rights within the human rights framework. Human rights experts have debunked this framing over and over again, including the UN mandate holders who submitted an amicus brief in the Dobbs case, explaining how international human rights law protects abortion and that overturning Roe v. Wade would contradict that law. And last, I want to note that despite all of these horrific developments, people are still having abortions, people are still providing abortions, people are still helping others access abortion, and people are still fighting back.
Thanks, Pilar. Miriam, do you want to go next, and we'll continue to sort of do an overview, and then we'll follow up.
Sure, I can follow Pilar. Thank you for the opportunity. So, I'm going to be talking about this through the perspective of climate and environmental justice and, human right to a healthy environment. And I just wanted to start off by saying that, when we think about the right to a healthy environment, which I think overlaps with the state's obligation to address.
Miriam, I think you're getting you're going in and out a little bit. Was that right? Were other people having that?
Oh, is this better now?
I think so. Maybe just stay the same distance from the microphone.
Plug in my headphones. I'm not calling from my usual workspace, so apologies for the technical issue.
No problem. We just really want to hear what you're saying. So
sure, no problem. Thank you for bearing with me, everyone. That's better?
I think so.
Okay, great. So I'll just restart again. So I'm going to be talking about this issue through the lens of climate and environmental justice and thinking about the human right to a healthy environment. But before I dive into, what this means in terms of the US government's compliance, I just wanted to acknowledge that when we think about the right to a healthy environment, which I think includes a state's obligation to address serious environmental threats such as the climate crisis, it's important to acknowledge the limitations that we have right now under international human rights law. I would say besides international agreements related to reducing emissions in response to climate change, which are not centered on a human rights framework, such as the Kyoto Protocol from 1997 and the Paris Agreement from 2015, there is no binding human rights convention that is completely centered on human rights and the environment. I will note that there have been more recent positive developments in terms of resolutions. A few examples are the UN General Assembly's resolution from last year, which confirms that everyone has the right to a healthy environment. And another example is a resolution also from last year from the Inter-American Commission on Human Rights, acknowledging the climate emergency and states' obligations to do more to protect communities and really try to reduce industry that's playing a role in exacerbating the crisis. And I think this is really important because, environmental rights, is very intersectional and, touches upon all of the topics that are coming up in this panel. And so, it relates to Indigenous rights, it relates to reproductive rights and migrant rights, especially as we see the environment playing a role in driving migration. And, while I think there's, a lot of opportunities to create stronger human rights norms, it's, I don't think a surprise to anyone that US law and policy still falls short. I'd say from a comparative legal perspective, our Constitution does not provide a right to a healthy environment, compared to other countries. We do have federal and state laws that address pollution, such as the Clean Water Act and the Clean Air Act, but we don't have a specific federal environmental law that explicitly addresses environmental injustices that really overburdens communities of color throughout the country. But I think it's important to keep in mind that when we're figuring out, how the US government can do more to uphold human rights norms, I think that an important role is through regulation, through environmental regulations and pollution standards. And I think that is, plays a role in establishing a foundation to realizing the right to a healthy environment. And I will say that, these norms created or these standards created at the federal level, I think it's also important when we think about state and local protective measures. But I will say that there are a few key Supreme Court precedents. I'm going to be talking about West Virginia versus the Environmental Protection Agency and Sackett versus the Environmental Protection Agency, which shows a judicial backlash against the federal government's ability to regulate environmental protections and thus, try to uphold human rights norms to the extent possible. I will say that our conservative Supreme Court is really limiting the tools that the federal government has through the Environmental Protection Agency and how it can protect our environment through the Clean Air Act and Clean Water Act. So I'll start with a quick overview of West Virginia versus EPA, which I'm sure many of you are very familiar with, but this is concerning a program that EPA had promulgated in 2015, and this is known as the Clean Power Plan rule, which they established through a provision of the Clean Air Act. And this plan was to address carbon dioxide emissions from existing coal and natural gas-fired power plants. And, there's significance to this role when we think about climate change and how carbon dioxide emissions are significant, pose a real risk. I won't get into the crazy procedural posture of this case, but let's just say the Supreme Court decided that the provision that EPA relied on did not give it the authority to set emission limits for existing power plants. And I want to, really note that this decision, while it was unfortunate, did not eliminate EPA's authority to regulate greenhouse gas emissions overall. It still establishes a troubling precedent because the Supreme Court relied on a doctrine that is not very well developed called the Major Questions Doctrine, where basically they're saying that trying to say that EPA's decision had major economic and political consequences and that they specifically needed authorization in law by Congress. And so I think that there's a risk of this being used, of the Major Questions Doctrine being used more in the future to challenge more or future environmental regulation. So that decision came out that last year, and more recently we have Sackett versus EPA, and this is about the Clean Water Act, which protects certain bodies of water from pollution and destruction. And bodies of water that fall under the protection of the Clean Water Act are known as waters of the United States. And in Sackett, the Supreme Court was looking at what types of wetlands are protected under the Clean Water Act and thus fall under this definition of waters of the United States. And the court decided to reject EPA's more expansive interpretation of which wetlands could be protected, and instead applied a more restrictive definition, which now has the effect of limiting which wetlands can be protected. And I think this case shows the lack of deference that the Supreme Court had for EPA's interpretation, which was more inclusive, and it was really rooted in more scientific analysis and understanding of how pollution of wetlands is harmful for the environment. And so I think these Supreme Court decisions, while some could argue that they are narrow in scope, but in terms of how they have limited EPA's regulatory ability, but again, they set this concerning precedent for the judiciary weighing in on when environmental protective measures are appropriate. And I think this is very concerning from a human rights perspective, because, you know, while our baseline is pretty flawed to begin with, I think that, you know, by limiting what can happen at the federal level also can enable more extreme state regulation that does not favor the environment and is more pro-industry or, you know, other activity that is very detrimental. I think a significant example, which I'm going to rely on because I'm currently traveling in North Carolina, where you have a lot of environmental concerns connected to concentrated animal facilities or CAFOs, so hog farms and CAFOs for poultry, and this has created a lot of extreme environmental injustice, especially in communities of color. But this industry really does not have much regulation or oversight on the federal or on the state level, and so I think this is an example of how we have this heightened risk with the judiciary pushback against federal regulation, and how, you know, the capture of industry in state government can lead to, you know, an impunity for industry such as what we are seeing in North Carolina. Anyways, I just wanted to leave on that note, and thank you, Cindy.
Yeah, thanks, Miriam. I mean, I feel like that's fascinating when we think about how do we comply with human rights, right? And the role that the federal government could be playing affirmatively, right? And how the Supreme Court's really taking away their power to do so. So that's a really interesting perspective. Patty, do you want to take the reins?
Sure. Hi, everyone. So happy to participate today. I just want to note that colonialism has had a really negative impact on tribal communities in the United States. And it has impacted many of the human rights of Native peoples. And I think it's important to mention that, and how the doctrine of discovery and colonialism have been used to take away lands, to remove people, to assimilate people, to disregard them even as human beings, and including dispossessing them, like precluding them from participating in voting, or even being consulted with regards to how their lands are being used, what is being done on their lands, and it continues to have negative consequences. So tribal people are still feeling the effects of this. It's embedded in Supreme Court law, and also in legal doctrine and statutes. And the words that are used are very negative, and it creates a form of bias that permeates everything. And so now tribes are having to react to that and trying to be proactive and responding to the situation which they are in, which is, in my view, very negative. My work focuses on self-determination, environmental issues, protecting sacred sites, voting rights, and exercising tribal law in a variety of areas. And as many of you probably know, tribes have inherent sovereignty, that they have that whether or not the U.S. recognizes it, and they don't for certain tribes, and they don't even for certain things. They have rights to their land, water, subsistence, rights to hunting and fishing, and a right to their identity. But many decisions made about these land and resources now continues to impact their right to self-determination, their right to life, their right to safe drinking water. And a lot of these decisions have been made without the input of tribes, even though there is a duty to consult with tribes. And in the Declaration on the Rights of Indigenous Peoples, it specifically sets forth free and prior informed consent. The ability to address these issues are challenging if tribes are not able to fully participate in the democracy and the voting systems. And I think we all know that there's challenges with political participation in general for people of color, and the way that they draw district lines, and the amount of effort to suppress voting is impacts the ability of tribes to be responsive and have people represent them in their issues, because tribes are a lot of their issues are decided on the federal level. So if they don't have representation in Congress, or whoever's being appointed to oversee something that directly impacts them. So I just want to mention, because I'm sure people are interested in the current term of the Supreme Court, and then I want to mention some other things that I'm working on, but definitely there's today the Supreme Court issued a decision in the Brackeen case, which deals with children, and that the Indian Child Welfare Act was put into place because children are important to the continued existence of the tribe. And the United States actually had policy in place which allowed children to be removed from their homes, whether it was for boarding schools, many of them died, or whether it was for adoption, because they didn't the standards that tribes had to raise their children in, they didn't respect or appreciate that. And so this law was put into place because so many children were being removed. And so actually today, the Supreme Court did uphold Brackeen. I will say there were conversations, and there was another ICWA case that came up a few years ago as to whether advocates should argue international principles with regards to child welfare in their briefs, and people didn't think it was right. But I will say that tribes themselves are starting to incorporate the Declaration and human rights measures into their own tribal laws. And I looked at the decision briefly. It came out this morning, and there wasn't I didn't see any reference to human rights in there, but I think it's a very important decision because there have been constant attacks on tribal children, and tribal children are the future of the tribe, and it impacts their right to be free from assimilation, discrimination, and forced removal. So that's very important. I'll also mention another case, which is the Navajo Nation water case, and this is very important because the Navajo Nation is the largest reservation in the United States. The tribe entered into treaties with the United States, and subject to that treaty, as a tribe believed that they should have an allocation of water that went with that. As we see with COVID-19, many people aren't aware of what's going on in Indian country, but with COVID-19, some of the highest rates of death were in Indian country. One of the reasons for that is the lack of water and the lack of housing, and multi-generations living in one home without any water or plumbing. About 30% of the members of the Navajo Nation do not have running water. So they have to haul water, even though they should have been allocated water to their reservation. So they filed suit saying, the US as the trustee, you should be ensuring that we have our water rights. That's what we agreed to in this treaty. And the US basically said, well, we don't have a right to ensure that you have these rights. And there's been a lot of adjudication going on with that with regards to water rights. And I would just say for many tribes, I'm on the lands of the Akimel Apam right now, they were the ones who created the irrigation systems for the valley, but the water was then blocked upstream by other water users, which basically meant they no longer have water to grow their crops. And right now that tribe has the highest rate of diabetes in the United States because they were forced to rely on commodities and other foods. And so not having this water has long-term effects on people's lives, and in their current lives. So we're still waiting for a decision. That's just all just to say, like, it's very important to have this water, but how we think of water is that we are allowing other users to use this water, even though indigenous people should have the right to the water that passes through their lands and their aquifers and things of that nature. Or if they have been removed, they should have a right to have water and resources to support their livelihoods. So that's all to say, we're waiting for this decision in this Navajo water case. It hasn't yet been issued. So just to let you know. And the other thing that I just want to mention real briefly for the things that I'm working on, I'm from a tribe in coastal Louisiana. My tribe is not recognized. And we are in the fastest eroding basin in the United States, which means that we have lost about 90% of our homeland. We cannot grow crops on our homeland. People have had to relocate. And people, can't raise cattle and had to totally change their lifestyle. There has not been any consultation with our tribes with regards to that. It impacts our daily lives. Our sacred sites are threatened or currently threatened. And it puts us at risk for flooding and also for severe storms. And a lot of this has to do with how, what we see as important, and which is, extraction of oil and gas or other resources at the expense of people's lives. And I've been looking a lot at cultural heritage and how cultural heritage is a human right, but how that is not taken into account or valued really domestically, especially when these decisions are being made, that, monetarily, it's the extraction of resources seem to outweigh that. I will say that PHRGE has done a review of the US and, looking at the lack of federal recognition and the recognition process, they have identified as problematic. They have also, these economic activities by these corporations, they have said impacts the way of life of minority groups and indigenous people. But the ongoing issue with regards to the lack of recognition has been recognized by not only the UN and the country report, I think in 2012 or 2014, but most recently PHRGE. And that impacts the ability of these coastal tribes to exercise their rights to self-determination. And so I really just wanted to end on the voting rights case that just was issued. I know that impacts all minority voters, but the Supreme Court has really stripped away the voting rights in this country through the protections that were in place. And we know that people have a right to political participation, and that right is impacted when those rights can't be exercised because of laws that are passed. But last week there was a decision basically to maintain in place Section 2 of the Voting Rights Act for redistricting, which is positive for minority communities, and tribes have used that effectively to ensure that they have representation. So anyway, I just want to end on that. Thank you for allowing me to participate.
Thanks, Patty. I think Jennifer has something for us before we.
I have the second CLE code for New York participants. That is FY78J3. FY78J3. Thank you.
Thanks, Jen. Okay, so Ian.
Good morning, good afternoon, good evening, colleagues. Thanks for your time. Thanks to the organizers for putting together such a wonderful event. And thanks, Professor Suhu, for moderating. And thank you all so far. Your remarks have been inspiring and engaging. And makes for a tough act to follow. I just wanted to begin because I'm coming to you from Cornell University to note that the university is located on the traditional homelands of the Kayakono Nation, the Cayuga Nation, members of the Haudenosaunee Confederacy, an alliance of 6 sovereign nations with a historic and contemporary presence on this land. The Confederacy precedes the establishment of Cornell or New York State or the United States, and we as a university acknowledge the painful history of Kayakono dispossession and honor the ongoing connection of the people past and present to the lands and waters. But in addition to the university's formal land acknowledgement, which has been reviewed and approved by the Kayakono traditional leadership, but separate from it, I just want to emphasize that Cornell's founding as a university was enabled in the course of a genocide by the sale of almost 1 million acres of stolen land under the Morrill Act of 1862, and that the university hasn't officially acknowledged its complicity in the theft or addressed the degree to which the ongoing wealth of the university is linked to that history. So just to jump into this issue of how the U.S. falls short on human rights standards is a tremendous challenge, as we've already heard. It covers so many facets of our life and so many areas of fundamental rights violations in the United States. I'm going to focus narrowly on the impact of recent Supreme Court decisions in the immigration area, and really just try to zero in on a couple of decisions for purposes of informing our discussion. That, of course, there's a long arc of the court limiting consideration of international and comparative law arguments raised by the parties. I was really interested in hearing about some of the different ways that those arguments are being raised to urge restriction of individual rights protections, but certainly in the area of seeking to justify expanding individual rights protections. There's a decreasing amount of citation and discussion when we think about human rights law. So I just want to zero in on 2 decisions taken in the immigration context in the last 5 years that have permitted domestic state practice to come to be in violation of the ICCPR. The first, Trump versus Hawaii, which concerned the legality of the so-called Muslim ban, which you'll all likely recall as one of the earliest and most contentious actions taken by the Trump administration in the immigration area. And second, a more recent case decided in 2021, Johnson v. Guzman Chavez, which concerned the authority to detain migrants who were previously deported, but then who returned to the United States and were found to possess a credible fear of return to persecution or torture. So I'm choosing those 2 cases because I think they're the cases in the last few years that most clearly and directly engage ICCPR provisions, and I'll say a little bit more about that. And I also think that in the stream of immigration court cases before the court in recent terms, not only do they most significantly and kind of clearly present ICCPR issues, but I also think that these are the 2 most recent cases where via amicus, as well as to some degree party briefing, as I'll talk about, international law was put before the court in the immigration area. So as you'll all recall, perhaps the Muslim ban had a long history, but the ultimate proclamation that was reviewed by the Supreme Court in the Trump v. Hawaii case was ultimately issued in September 2017. It restricted the entry of nationals from 8 countries to the United States: Chad, Iran, Iraq, Libya, North Korea, Syria, Venezuela, and Yemen, and came to tailor those restrictions as a function of how each country vetted its nationals. That degree of justification wasn't present in the earlier forms of the executive order, and not all of the countries on that 3rd executive order were originally barred in the initial Muslim ban. The stated objective of the executive order was to support foreign policy, national security, and counterterrorism by excluding inadequately vetted foreign nationals. And the court ultimately held that the president had not violated the law, neither statutory or constitutional law, and thus that the plaintiffs were not likely to succeed on their claims. So in doing so, the court did hold that the plaintiffs had standing, mostly because they had been separated from certain relatives who sought to enter the country. And on the merits, although plaintiffs had argued that the president, through his comments on Islam, had cast doubt on the official objective of the executive order, and therefore violated the Establishment Clause of the Constitution. The court rejected it, although it did look behind the executive order to consider those statements, ended up determining that because the executive order could be reasonably understood as a result of the justification that were independent of the unconstitutional grounds, it was lawful. So as the overview of this logic suggests, the ICCPR wasn't central to the court's decision. You won't see long discussions of the treaty or its terms in the opinion of the court. But amici, represented by Professor Aaron Fellmeth, observed that the proclamation made an explicit distinction based on national origin and an effectively implicit distinction on the basis of religion, and that under international law and the ICCPR, unless that kind of a distinction was necessary and tailored to achieve a legitimate government aim, it would violate the obligations under the treaty. So under that treaty, the amici urged that the measure was not appropriate to achieve an objective aim. It wasn't narrowly tailored, and it unduly burdened the exercise of other human rights. And I'll put the link to that amicus brief in the chat. In moving on to the detention case, respondents who were asylum seekers who had been removed from the United States and then re-entered without authorization. The Department of Homeland Security reinstated that prior removal order, even as it found each of the respondents in the class to have a credible fear of returning to their home country, either a credible fear of risk of persecution or of torture. And under US law, statutes, when a person has been previously removed, there's a mechanism to be for that previous removal order to be reinstated, and that allows the government to expeditiously remove the non-citizen. However, the procedures allow the expression of a fear of return and then a processing for withholding of removal of protection against return, but not a permanent status, and not a destruction of the removal order, but just sort of a holding in abeyance of the removal. And that order isn't subject to being reopened or reviewed, but the lower court had held that that class of asylum seekers were eligible for bond, so a review for potential release from detention, because otherwise US immigration law mandates detention for those subject to removal in this way. The government had argued that they were not eligible for release and appealed and won. And so therefore, as a result of this decision, which was a statutory decision interpreting which section of the Immigration and Nationality Act applied to the detention, and therefore whether bond was available as of right, or whether detention was mandated, and the only avenue out of detention for these asylum seekers was the discretion of the Immigration and Customs Enforcement Agency. And so as a result, detention and mandatory detention of this particular class of asylum seekers is now required under US law. So the treaty, in this case, the treaty-based duties of the United States to provide protection against return to torture or persecution, so not the ICCPR, but other important international law duties were cited even by the government's brief and acknowledged in lower court decisions. But the ICCPR did not play a significant role in the court's decision or the respondent, the asylum seeker's brief, despite the practical consequence of the case coming to justify a mandatory detention of these asylum seekers. But in an amicus brief by Eugene Galernter on behalf of Human Rights First and international law scholars, the parties, or the amici, raised the ICCPR. So Article 9 of the ICCPR, of course, provides that every person has the right to liberty and shall not be subject to arbitrary arrest and detention. And the amicus brief cited General Comment 35 and the need to assess reasonableness, necessity, and proportionality under an individualized assessment, which mandatory detention of this class necessarily didn't do. So I'll put that amicus brief link in the chat as well. So these two cases, in neither opinion did the court reflect on the ICCPR. But the amicus briefs raised similar arguments about why the international law obligations under the ICCPR were relevant, that the Constitution and precedent, even for non-self-executing treaties, created duties that have to be implemented by all levels of government, that courts have to construe both the Constitution and statutes, as these cases raise both of those areas of law, in a manner consistent with human rights law, and must avoid putting the U.S. in breach of its duties, as well that the government or that the president had a duty to faithfully execute the U.S. international law obligations, even if a domestic statute didn't formally apply. So I highlight these cases and work through the sort of arguments here, both to provide some encouragement to working through the specific doctrinal arguments on the ICCPR before the courts, and I'll have a lot to say in the second segment of the panel, but to just make a few key points. First, in summary, certain recent immigration cases resulted in outcomes that clearly and sort of facially take the U.S. out of compliance with its international obligations, at least in respect to a particular population or a particular area of the ICCPR. Second, that the risk of the U.S. coming to be out of compliance with the ICCPR was raised primarily by amici, that it was not central to either of the parties' briefs. It wasn't addressed at oral argument in either of these cases. It wasn't addressed by the government in any detail other than in the way that I described earlier in one of the cases. And I'm talking about cases from 2018 and 2021 because one of the trends here is that those two are really the immigration cases where these human rights law issues were most briefed at the greatest length by amici. More recent cases have not deeply delved in this, and I think that's an important pattern in the immigration area to note in relation to practitioners practicing before the Supreme Court as to how they're raising these arguments or not raising them, as the case may be. The third, that the amici, as I just summarized, really focused their arguments on international law and UN interpretation of international law. There wasn't a lot of comparative practice. So, and so by way of closing, I just want to, I suppose, note that even though I've gone through all of this in this way, I do want to emphasize that these things aren't surprising, of course, given the political dynamics, the composition of the court, including the change composition since the 2018 decision, and the views of sitting justices on the relevance and status of both international and comparative law, and the precedent in this area, and in particularly the court's decision in Medellin, which limits the application of the ICCPR as a matter of domestic law, make these trends not particularly surprising. I do think there's some things we can do about this, but I think that's where I'll pause for now. Thanks.
Thanks, Ian. So I have one follow-up, and so people might think, as we're sort of responding to this follow-up, people can think about if they have a specific question they want to ask. And I think, Ian, you kind of really led us to this into this next question, really, because we are facing an environment where I think the Supreme Court is much less interested in international and comparative law arguments, or maybe, as Pilar said, sometimes considering them in a negative way. So, like, what are the ways that you all are thinking about using human rights law, human rights strategies to move your issues forward? And we
want to go in reverse order.
Do you want to go in reverse order, and then you will have or we can. Well, Ian, why don't you go, and then we can popcorn, I guess, after that.
All right, I'll keep it very brief. So I think in terms of what to do, my view is that even if everyone is even if there's cause for some pessimism, I think we should all still be citing to public international law, and I would urge people to also cite to comparative law and comparative practice implementing the treaties. So, citing to what particular jurisdictions are doing and saying that the ICCPR obligates them to do, I think is important, and I think is actually rarely done. Second, where should we be doing this? I think doing it earlier than just at the Supreme Court. Do it at the district court stage. I know it's hard. Brief limits are tight, but put it above the line. Do it at all levels in state court as well. But I also think, given the importance of administrative law and the congressional record in some of these areas, particularly in the immigration area. The congressional record has often been cited in the relevance of international law. We should remember to be doing that advocacy and notice and comment, and of course when we're testifying on bills. Who should be doing it? You know, of course, all of this is framed around what litigants should be doing or amici should be doing, but I also think it's important for us who either are in the executive branch, might go in the executive branch, or know people in the executive branches to urge executive officials to rely on international law and to do that when they're justifying decisions or appearing as parties. They do that when they go to Geneva to talk about treaty practice before the treaty bodies, but they don't do it when they're briefing the same issues in US courts. And then the last thing that we've heard about, I think, you know, engage the international mechanisms. We've heard a lot about that across these different presentations and how important and useful it is to domestic advocacy. So, you know, we need to keep making that record so that it can be brought into court. And I'll stop there.
Patty, do you want to
Sure.
respond?
Yeah, so I would just like to follow up within, we filed a complaint after the Deepwater Horizon oil spill, and we included some violations of international law in our complaint in federal district court, just to highlight it, because I do think that, you know, implementing it into our, you know, comments, our scholarship, and how we can use this locally is very important. I will just share with you a couple of things that we've done. So in 2020, we filed a complaint with the UN body with 9 special rapporteurs dealing with climate displacement and environmental issues for 4 tribes in Louisiana and 1 in Alaska. And there was a response to that, and I can put that in the chat. And in the response from these special rapporteurs, they identified, you know, clearly for the US, like, these are all of the areas we think that you have violated. But because there were no responses under the last administration, there's a huge backlog to try to get some country visits. So that's unfortunate, because I think that could be used to highlight some of these issues. What we've done most recently, and we worked with Miriam at Earth Rights, is we were talking about a strategy on how to elevate these issues. And so we requested a thematic hearing before the Inter-American Commission on Human Rights, and it was on displaced people through indigenous peoples displaced through this climate issues. And so that hearing was held, and there was a follow-up visit by Radeska, the special rapporteur. I think it was 2 weeks ago. I feel like it was just maybe it was 3 weeks ago. So I think that's very positive, because it will help to highlight the issues impacting our communities, and hopefully there'll be some follow-up on that, just so it can raise the issues for, like, our Louisiana and Alaska officials, and they will have to respond to these violations and have the State Department involved. I think there just has to be some highlighting of this locally. I will also note, for the Declaration on the Rights of Indigenous People, there's an implementation project where people are talking about how to implement rights domestically. And the one other thing I'll mention is that Indigenous peoples have been participating heavily in the climate space and the Conference of the Parties. There's not a ton from the US who participate, just because of you know, getting involved in the expense and everything like that. But there is more people participating and more tribes participating in coordination. I think that's really important, to have people participating in those spaces and having access to those spaces, and then they can come back and work on implementing. Yeah, and I'll put this response in the chat.
Yeah, Patty, I mean, I feel like that's a good point that other people can build on as well. Just this idea of it's not just about bringing back the standards, but like our presence and building them, right? And Miriam.
Sure. So I'm gonna kind of elaborate on some of the points that Patty had mentioned. So, personally, most of my engagement in international human rights strategies has really been limited to, the thematic hearing and follow-up site visit from the Inter-American Commission on climate forced displacement of tribes in Louisiana and Alaska. And I just wanted to highlight that, I think the site visit from the mandate of REDESCA, which covers economic, social, cultural, environmental rights, I think is a great opportunity to really highlight how expansive environmental rights are and how it really interconnects with, Indigenous rights, especially right to self-determination, cultural heritage, right to life. But the fact that there are so many other rights at play here, including the right to health, the rights of a child, and kind of the need to have stronger norms on businessing human rights, because while the strategy focuses on the state, it's also the state that is permitting a lot of destructive extractive activities, which it exacerbates the risk or the impacts of climate change. And so I think that so I think this is an opportunity in which to build off of, and we're waiting for the commission to release a communication on the site visit hopefully soon, and either this month or next month. And I think another thing that came up through this engagement is how when a community has to relocate, how there needs to be stronger human rights norms to make sure that it is as community centered as possible. And so I think that's another opportunity which can also in turn influence discourse on loss and damage, which relocation is part of this, and also the importance of highlighting the experiences of frontline communities in the United States who bear some of the most severe impacts from the climate crisis. I did also want to quickly give a shout out to the work of my colleagues in our office in Peru, where they recently had a hearing at the Inter-American Court on Human Rights on behalf of the UA indigenous community in Colombia, and how their traditional lands have been threatened by years from oil extraction. And for their community, oil is sacred and should be kept in the ground. And it's I think while it's going to be a year before we get a final decision from the court, it's an important issue because it's really challenging the state's ability to claim ownership of subsurface resources on indigenous land. And I think this in turn could also be connected to climate and environmental rights. And I'll kind of end on that. Thank you.
Laura?
Yeah, thanks. So we're using human rights strategies in a number of ways. So we're doing human rights fact-finding projects, trying to make sure that violations of human rights are documented, that they're brought to light, that they're not erased or normalized. We're incorporating human rights standards and human rights analysis into the proactive work that we do at the federal and state level in terms of policy development and legislative solutions. We're looking at state courts, that protect the right to life, and thinking about ways that perhaps, we could use the human rights analysis to sort of influence the interpretation of some of the domestic rights that we still have. Of course, we're using these human rights spaces as platforms to draw attention to our issues and to build solidarity across movements and across spaces. I think we have the US has a lot to learn from advocates who have been working in really hostile legal contexts like Ireland and Latin America, but have also been part of this wave and trend of liberalization and increased access. So we have a lot to learn from other movements, and I think the human rights spaces facilitate that learning. US advocates also have insights of their own to share that are helpful with advocates and movements in other regions. So we're doing that too. And then I think, just most importantly, we're just being very vigilant about engaging in the places where law is made and not ceding that space. So whether it's the Supreme Court of the United States or international human rights law, at the end of the day, law is made by people. People have different beliefs and ideas. Those beliefs change over time, and law can change over time. So we're, trying to ensure that we are, as reproductive rights advocates, that we are part of that global conversation. We're part of those spaces. We're part of that norm development. And then I think we're also trying to make sure that we're living our human rights principles in doing that, right? So human rights teaches us that the people most impacted by a human rights violation have to be centered in identifying the problems and the solutions. And so, you know, whether that's in a courtroom or in Geneva, I think we're trying to lean into that and think about what our role is as lawyers in our different social movements in making those spaces more accessible to other folks in our movement. So I'll end there, and I will also follow this practice that I think Ian has started of dropping links and resources into the chat.
Great. So I think we have two questions. The first is I'm just scrolling, and maybe I'll pose those two questions, and that might actually be all we have time for. Actually, the first question is from Martha, which is, do you think U.S. courts are particularly hostile to or uneducated about economic and social rights? That's the first question, which I feel like is relevant to all of your work in different ways. And the second question is from Rosalie Gonzalez. And I think she said, particularly to Pilar or Patty, but others might have responses as well. CEDAW recently adopted General Recommendation number 39 on Indigenous women and girls. Organized Indigenous women around the world welcomed it because of the consultation process and because it acknowledges individual and collective rights. It will serve as an important instrument for Indigenous women. However, it's not applicable to Indigenous women in the US. Any thought or insight on the future of US adopting CEDAW? So maybe any thoughts first on the question about economic and social rights and US attitudes, courts' attitudes about economic and social rights, and how, you know, general observations or how it might be changing over time. I mean, I think it's interesting in terms of, you know, the public attitudes changing, you know, that we've seen within our lives in terms of economic and social rights, in terms of people talking about healthcare as a human right, housing as a human right, but maybe we haven't seen that as much in courts, right? And historically, well, I mean, I feel like there's maybe more room more movement at the state level.
Yeah, I did want to kind of comment on that, kind of, you know, what, you know, using the civil rights movement as an example, where, you know, I think we have this interesting culture where domestic human rights are, you know, framed as civil rights here, but how, you know, some of these economic and social rights have kind of been codified through the civil rights movement. When we think about the Fair Housing Act, when we think about, you know, protections under Title VI, we think about protections under Title VII, you know, anti-discrimination in the context of employment. And so I think that, you know, in some ways it's, you know, courts have been familiar with this for many years, but I kind of see it as more of an issue of language where, you know, I think there's a clear understanding of, you know, the civil rights framework, but, you know, can we do more to incorporate human rights norms into, you know, how we are applying civil rights laws and litigation.
Yeah, and certainly true. Like, you know, the way that we've looked at economic and social rights has almost been through also this anti-discrimination lens, right? Rather than just everyone has the right, you know, regardless of comparing this, you know, whether it's discriminatory or not, right? Which I feel like we have internationally. Martha, I don't know if there's other things that you wanted to get at with that question, or just generally as a economic and social rights person.
No, I think that's fine. Why don't you move on to the people who have comments on the CEDAW question?
Yeah, I mean, Patty and Pilar, have you been following this General Recommendation 39 from CEDAW?
I haven't followed the recommendation, but I've been following the missing and murdered Indigenous peoples, like what's been going on in that aspect. I know that there was something in the CERD review with regards to missing and murdered Indigenous people. And, the US response is that they're working aggressively to address this, but they're so behind. And again, the infrastructure is that in Indian country, a lot of times people can get away with things because there's jurisdictional voids, and people take advantage of Native people. There's been trafficking in the valley. There's been a lot of that going on. So I think that that's very challenging. So the US response to that, CERD, is that, oh, look, we created a committee and we have a proclamation and we're working on this. But from the Indigenous perspective, we are way behind, and there's a lot to do. And there are many missing and murdered Indigenous peoples who haven't even been investigated, because again, that bias, when people go and say, oh, someone is missing, and they don't even look into them. And then from the jurisdictional void is what I mean, is that tribes can't prosecute, in most cases, non-Indians on their land. And so perpetrators know that, and the feds decline. I know some people think these decisions the Supreme Court had in McGirt and Castro Huerta was, for Indian country in Oklahoma. Now they have some jurisdiction, but there's not a lot of, what do we say? Like a lot of jumping at the bit to try to prosecute people who are violating rights of children and women. But yeah, so it would be great if there were pressure on that. Rosalie may know more than me what's happening.
I would just add that I think pressure is also like the key. I think people and advocates make human rights relevant in the US, right? And so our social movements can do a lot to to make courts pay attention to the relevance of these. So the question about whether or not it's about being hostile or uneducated, I mean, maybe it could be both, right? But the more that people start to cite to international human rights law, the more that advocates think it's relevant in their own lives. When we have people like Rosalie who are participating, in the development of a CEDAW, in a CEDAW process, regardless of whether or not that's been ratified yet, like I think that that's also, she's making it relevant to the US. Like her experience is still relevant to that process, and and that global conversation, being a part of a global conversation about what human dignity and a life of dignity means, is a really important one for us all to participate in, regardless of whether or not we have adequate structures in place here in the US. And I think, to the point about is it possible, like what is the outlook on sort of getting that done? I know Jamil and others have been raising over and over again with the administration the possibility of a national human rights institution. And just, many folks have worked on that for a very long time. It's still worthwhile, even if the outlook seems dim, it's still worthwhile to keep raising it, to keep pointing out, we need these things, we need these things. We still haven't done that. The US still has not ratified this treaty. And I think, just it's kind of a long game, right? But the key, I think, is to keep pointing to those things that we need in terms of the infrastructure that will make human rights violations less likely to occur. What are the mechanisms that, that enhance and promote feedback and transparency and accountability and remedies? And being engaged in this global conversation with others about that, I think is key. We can use the learnings from that, whether our government formally calls it international human rights or not, and we can keep pressing for those things. So thank you to Rosalie and to everyone else who are continuing to participate, even when it seems unlikely to move in a short time.
Thanks, Pilar. So there's one more question for Ian, and I'm going to pose that. But in the meantime, I feel like Pilar, your remarks and conversation with Rosalie just also makes me think, maybe for a concluding question for you guys to think about, is there some international conversation or development of rights that you think US activists should be actively involved in, right? Because I think what we've talked about sort of bringing norms back, but is there some international dialogue or building of rights that we think that U.S. activists should be going out and being more involved in. But Ian, I'm going to ask you the question, which is, has the Human Rights Committee this is from the Haitian Bridge Alliance, and it has the Human Rights Committee made concluding observations on the U.S. maritime interdiction and forced return program and the 93 SCOTUS decision upholding it in its current form?
Yeah, great question. I don't know from memory whether that's been addressed. I don't believe so. Offhand, I don't have a recollection of it being raised. I think partially that's because it's often framed in relation to the Refugee Convention and not framed that the sort of the decision that is being discussed is a decision in the early 90s where the extraterritorial application of the Refugee Convention was before the United States Supreme Court. It's like one of the few cases where the Supreme Court was really called on to interpret human rights law directly as a core piece of a case. And there the court held that the Refugee Convention did not bind the United States in its interdiction, maritime processing and return of Haitian migrants on the high seas, asylum seekers on the high seas. It was actually something where even the executive branch had indicated that it viewed that the Refugee Convention applied. But because that fight was primarily focused on the Refugee Convention and not the ICCPR, I'm not sure whether that's been put before the Human Rights Committee. But actually linking, Cindy, to your general question about sort of norm promotion, I think this is an area also connecting with some of the important climate work where immigration advocates, I think, should be working at the international level to focus on the way in which the ICCPR's prohibition on return to torture, as well as arguably the prohibition on return to violation of other serious human rights, like the violation of the right to life, create a non-refoulement or non-return obligation that's binding on states and binding on the United States. And I think that's really significant in this area, and it links to that 1993 decision because it could be very useful as we think about climate displacement to be able to point to the ICCPR as a source for obligations of states not to return people to violations of the right to life or places where their homelands have been destroyed by rising sea levels. So that's a place where I think even U.S. advocates who maybe don't feel like the judiciary domestically is keen to cite that should be working internationally to expand the recognition of that norm abroad.
Miriam, do you have anything you think that U.S. activists should be more involved in?
Sure. I think, while we're thinking about ways to improve accountability at the state level, thinking about the role of private actors, especially businesses who play a large role in environmental abuses. And, I understand that there is a treaty process for Convention on Business and Human Rights, where I think there could be more opportunities to engage, especially, similar to Ian's point about lack of judicial interest in doing more here, seeing if we can play a role in strengthening that obligation when we think about how we define responsibility and access to remedies for affected communities. So, I think, we should be not just thinking about the state's responsibility, but how we can also hold businesses accountable because they play a large role in the perpetration of human rights violations.
Pilar?
I agree with my colleagues as much as I would like to say it's my own issue that I work on. I agree with my colleagues. I think that this issue of climate justice really has a way of demonstrating how interconnected people are across political boundaries in a way that is sometimes a little bit harder, I think, for other human rights issues. And I think there's just a lot of power in that. And related to that, because US is home to so many, very large corporations and businesses that have impacts around the world, including, impacts on the environment, I think that's a really compelling argument for advocates, human rights advocates, working on a variety of different issues in the U.S. to really be paying attention to those developments. And I would also say I learned a lot from my colleagues here, and I'm very excited about all the things they shared.
Okay, all right, Patty.
Yeah, I'll just follow up because I've seen how people getting together and planning can help elevate the issues. So, for example, I think in 2000, I don't remember when it was, there was a meeting in New York. It was at Pocantico. I'm sure I said that wrong, about how to integrate cultural heritage into the climate discussions. And then 2 years ago, when I was at the COP, there was, people who were there, and they're have these side presentations and different things where they're, bringing people in, having those conversations, because that really is like climate impacts everybody. But, cultural heritage is one of those things that people aren't thinking about in the climate conversations, and how you can maintain that in the face of this extreme climate displacement or things that are happening, because we have things that protect buildings, but not necessarily people and their ways of life. So I've seen that be really effective. So mobilization is pretty effective. I will say there's also this legal justice coalition calling for equity and justice in response to climate forced displacement, just getting ideas out there, trying to elevate, these human rights issues and getting buy-in, and trying to show the administration or different offices how you can implement that. And then with the missing and murdered Indigenous peoples, of course, we have to get buy-in from across communities. So you can see that being elevated, and people working together, having a symbol for something. And, I think that's really important. And I think that works, whatever the issue is just, I think young people with social media skills have a way to connect with people, and we should be relying on them because they're the future and they have a lot of energy in these spaces.
Thanks, Patty. Thank you guys so much. I'm glad I asked that last question. All right, we're running over, so I'm gonna turn it back to Martha. But thank you all.
So thanks to everyone on the panel, and to Professor Suhu for tackling this challenging, very topical subject right now at the end of the Supreme Court term. We've still got several big cases coming down this term, and they'll be out soon. So I want to now turn to our second panel, which will be looking at the treaty review process itself in the US. And as was already mentioned, many folks in civil society are gearing up for the ICCPR review in October in Geneva, and also looking at the operation of other UN review mechanisms or special procedures, as we heard earlier. This panel of experts will share their expertise on how to engage with the process, as well as suggestions for improving the process on the part of the US. I'm excited that Lisa Reinsberg, the founder and executive director of the International Justice Resource Center, will moderate and introduce the speakers. But I think that before we move to that, Jennifer is going to jump in and give us a code. So Jennifer, are you ready to do that?
Yes. So the third code for the New York CLE is PHRGE 92D6. KG 92D6.
And that's K as in kangaroo, right? G92D6. D is in David 6. Great. Okay, Lisa, I'm going to turn it over to you. Thank you very much.
Thank you so much, Martha. Thank you to Jen, everybody at PHRGE for bringing us all together, for making the space for these conversations. Martha, you have been so generous with me personally and with this community that I think you could ask me to do anything and I would do it. So it's pretty lucky that what you've asked me to do today is something that I will very much enjoy. And that is to ask a series of questions to these four experts that we have with us today to share their different areas of expertise and perspectives on the treaty review process. So I'll introduce them. We have Margaret Wang, the CEO of the Southern Poverty Law Center, SPLC, who in her current role and in prior roles has worked to combat hate and advance justice in the United States, including through engagement with different UN bodies. Next, Dr. Elisa Warren, who is president of the International Association of Official Human Rights Agencies, and whose career has been focused on promoting equality, including now through IORA's work with state and municipal rights commissions. Next, Dr. Domenico Zappoli, who is project coordinator of the Geneva Human Rights Platform and a research fellow with the Geneva Academy, where he researches and contributes to the accessibility and effectiveness of the UN Human Rights Treaty bodies, among other projects. And Karen Stevens, who joins us as respondent and is Policy Senior Counsel and Coordinator of the US Department of Justice Civil Rights Division's international program, where her work includes representing the US government before international human rights mechanisms, including treaty bodies. So thank you, all of you, for being with us today. As you know, our plan is to have kind of 2 rounds of questions, and then we'll turn it over to the audience for their questions as well, which you're free to put into the chat as we go along. But before we get to those questions, just wanted to take a minute to outline, for those who are not already very familiar with the treaty review process, sort of what that looks like, particularly with this ongoing review of the United States under the International Covenant on Civil and Political Rights, or ICCPR. So there's been reference to this process, to this treaty, like other UN human rights treaties that the US has ratified. The ICCPR establishes an oversight body, the Human Rights Committee, and a procedure for reviewing government's implementation of the treaty provisions. The committee conducts this review through a process that has both written and oral components. And so far, more than 56 civil society organizations have submitted written reports to inform the focus of this review, and they did that back in January of 2019. The committee then adopted its list of issues, which the US government responded to in its written report that it submitted somewhat late in January 2021. As Jamil said earlier, the next major step is an in-person meeting between the Human Rights Committee and the US governmental delegation, which is scheduled to take place in October. And that constructive dialogue is kind of a Q&A session between the committee members and the governmental representatives, and that's held in public. As Jamil also noted, the US government has held and is holding consultations with civil society as part of this process. And then the Human Rights Committee itself provides 2 more opportunities for civil society input ahead of the constructive dialogue. The first being written submissions that are due on my birthday of September 12th, and then in-person or possibly virtual participation in a private briefing with the committee members that would take place in the days just before the constructive dialogue. And then the sort of culmination of this process is the adoption of the concluding observations, which is a written document where the committee will identify the progress that has been made in implementation, but of course also the gaps and some recommendations for how to fill those gaps. It will request follow-up reporting from the government, and civil society can contribute in that phase as well through written reports. And then comes the longer task of taking those recommendations from the Human Rights Committee and turning them into policy, law, programs, and that is work, of course, that many of you will be involved in. So we'll start first with the process leading up to the concluding observations. And Margaret, I'll start with you. What has the experience been in the past for US focused organizations in terms of participation in the review process? To your mind, what are some of the most important moments for engagement?
Thanks so much, Lisa. It's a great privilege to join all of you and especially my colleagues on the panel. You asked probably the most critical question, which is why should advocates in the United States utilize this system when there are so many other tools or so many other approaches that we're seeking to use to advance civil and human rights here in the United States? And I think the answer is that it can be incredibly strategic, but it is typically not the only answer. for advancing human rights protections domestically. And that is for a whole host of reasons that my colleagues on the panel are going to get into, including the non-self-execution clauses of US ratifications of international treaties, including the lack of infrastructure that we have here in the United States to actually participate formally in preparing for these reviews. And we'll talk about that a little more. But what I thought might be most useful is to actually share some examples of how engagement with this process and with the treaty bodies has actually been a really big help to advocates here in the United States to give some really specific examples of where it's made a difference. So I've thought of 3 to share with all of you today. The first is actually from the last Universal Periodic Review of the United States, which took place in 2015. Interestingly, there was a tremendous amount of advocacy around the issue of criminalization of the homeless in the United States, the unhoused population. And the US received quite a number of recommendations from other states, from other state parties about addressing this concern. Because of the focus and the attention that the Universal Periodic Review process leveraged on this subject, the HUD department, Housing and Urban Development Department, actually revamped the questionnaire that it uses in the process of awarding block grant funding to address homelessness prevention and other services. And they actually changed the criteria by which they used measures to determine how much funding individual states might receive. And that actually had a huge impact. If a state government sought to criminalize activities like sleeping on a sidewalk, then they lost points and therefore lost funding for the services that they were seeking to provide in their states. This success actually worked for a number of years until administrations changed. And so in 2016 or 2017, after the Trump administration was elected, we actually saw significant cuts to all funding for housing programs and for homelessness assistance. And obviously there's a lot we can get into about the difference in administrations, but I think it's worth highlighting that this was a direct outcome of the advocacy of US organizations and the willingness of the previous administration to address this issue as a priority. And it did lead to some concrete changes and particularly funding availability on the ground. A second issue is actually from the CERD review last August, and this is where my own organization saw some real progress. Catherine Lehman, who is the head of the Office for Civil Rights at the Department of Education, was part of the US government delegation in Geneva, and she emphasized her eagerness to work with civil society in addressing the concerns that many of us had about rights to education in the US. So we followed up with her and actually requested that she specifically look at an issue in Louisiana. Recently, the state of Louisiana decided to detain youth to move the juvenile justice system to the infamous Angola prison in Louisiana, which is one of the most well-known prisons internationally for its poor conditions, its treatment of the detainees in that facility, and issues of violence and corruption that are pervasive in that institution, that facility. Because of our request to work with her as part of the follow-up to the CERD review, the Department of Education is now conducting an investigation into whether or not the children that are being housed at Angola are receiving the education to which they are entitled, including special services for those with learning disabilities. I can tell you based on our own research and legal services in the prison, we know that that is not happening, but having the Department of Education say it rather than my organization say it makes a big difference in the way that the state of Louisiana will address the issue. The last example I wanted to share with you is actually an extraordinary story that goes back almost 2 decades now. In the May 2006 UN Committee Against Torture review of the United States, there was an incredible focus on the problem of former police commander John Burge and his torture of African-American suspects in the Chicago City police system. It was well documented that he led a department of police officers who used torture against various suspects. More than 115 people were actually tortured into confessing crimes that they did not commit. While the city conducted investigations, agreed that that had happened, they refused to prosecute because they felt that the torture had actually passed a statute of limitations. We don't, of course, have a torture statute in the United States. They were using other criminal statutes, and those statutes had passed their ability to be used. Because of the scrutiny of the UN Committee Against Torture and the calls on both Chicago and the US federal government that they had to address this issue, the city ended up reconsidering and ultimately prosecuting John Burge for perjury, which is of course not at all the same, but he was convicted and he did serve time for lying under oath about his torture of those victims. More importantly, the advocates on the ground in Chicago used the recognition of this torture that had taken place to win an extraordinary package of reparations. It is the first time, to my knowledge, that a government inside the United States recognized organized government violence against American citizens and awarded them reparations for the harm. They allocated resources so that each of the torture survivors would receive nearly $100,000 apiece. All of the survivors and their families have the benefit of a free Chicago junior college tuition paid for, and a counseling center to help with both education and employment opportunities. Perhaps most importantly, Chicago public schools are now teaching the history of police torture to all 8th and 10th graders in all of the schools of Chicago. And there has been a process to erect a public memorial to the survivors of the torture in Chicago. This kind of extraordinary outcome is truly unique in the United States, but it is also very much attributed by the survivors and the advocates who worked with them to the interventions of the international committees and their insistence that the US hold themselves accountable on this issue. Thanks, Lisa.
Thank you so much, Margaret. That really sets the scene, I think, for why this matters, this kind of engagement matters. And you referenced the importance of political will and also how many different agencies can be relevant to human rights implementation, which I think sets up this next question for Elisa. So many countries have created a national human rights institution, or an NHRI, to serve as a focal point, as a liaison on domestic human rights issues, vis-a-vis sometimes international oversight mechanisms. But as we know, the US does not have an NHRI. So in the meantime, how does your organization, the International Association of Official Human Rights Agencies, help to bridge that gap?
Well, thank you, Lisa. First, I just want to thank this body for inviting me here today, and I'm honored to be here with my esteemed colleagues, and thank you for the question. So, as you said, you know, the United States is one of very few Western democracies without a national human rights institution. So nearly 120 nations have NHRIs that collaborate across national boundaries to promote human rights and provide mutual support worldwide. So despite the recognized importance of state and local agencies in effective human rights promotion and protections within the United States, there are no coordinated federal efforts to engage state and local partners in implementation within the U.S. So unfortunately, right now, the U.S. is missing from that dialogue. However, I am here with good news to say that I am proud to say that the International Association of Official Human Rights Agencies, or IORA, the acronym, is working hard to bridge that gap. IORA is a professional membership organization of state and local civil and human rights and human relations agencies throughout the United States and beyond. we were established in 1949 and are the most enduring network of statutory human rights leaders. So our mission intersects directly with the U.S. government's obligations to the international human rights treaties, because we work every day to unite, to educate, to strengthen state and local government, civil and human rights agencies within our nation and beyond. And IORA provides the leadership, the tools, and the knowledge to bridge that gap and to bring human rights home to the United States. We serve over 250 million people within our member agency jurisdictions, where we work to enforce, promote, and protect civil and human rights laws in our communities. Our government agencies enforce federal, state, county, and city anti-discrimination laws in employment, in housing, and public accommodations, and more. We're dedicated to the education and training and engagement of communities and leaders to advance healthier communities and more intergroup relations. So IORA members stand in the gap where the United States obligations are unmet due to the lack of an NHRA and other national responsibilities. IORA helps to achieve the human rights agenda on the state and local level every day through the enforcement of human rights laws, the education and training, and targeted community outreach. So we work to enhance coordination and information sharing across state and local and national boundaries, which is critical for the effective practices to maximize the impacts of human rights in our country. IORA plays a critical role in locally as a convener and is directly involved in discussing and implementing the dialogue around the human rights landscape. It's very challenging as state and local entities to participate in the process when there is not a high priority always placed on human rights. However, it continues to be our mission to bring human rights home to the U.S. We join a broad coalition of other organizations to urge the administration to create a commission to study the establishment of an NHRI in the United States. Other countries, in other countries, NHRIs take the leadership role in promoting and facilitating human rights education by providing support and coordination. So we're hopeful that the U.S. NHRI will be put in place and to amplify the voices of state and local human rights agencies at the national level. And IORA, as we have for 75 years, will be there to do the heavy lifting as we all grapple with domestic human rights issues like racial justice, hate crimes, housing access, and other critical human rights issues. The United States has repeatedly affirmed that state and local governments are vital to the comprehensive human rights implementation throughout the country. The United States Department has even emphasized that the best human rights implementation combines overlapping enforcement with federal government working side by side with state and local partners. IORA is a proud partner and the umbrella organization for human rights leadership.
Thank you so much, Elisa. It's great to hear the enthusiasm and all of the emphasis on partnership. Domenico, some of the challenges that Elisa was referring to in terms of coordination and participation are part of the motivation behind an ongoing treaty body strengthening process. Can you tell us some of the changes that are being proposed to how the treaty bodies themselves work and how that might impact engagement by governments or by civil society?
Of course. Good afternoon, everyone. Good evening and good afternoon from Geneva. Thank you, Lisa, for the question, and thank you, Professor Davis and the organizers for inviting me to this very timely discussion. So far, since the beginning of this conference, we have discussed how important it is that national human rights systems develop towards most efficient human rights implementation practices. We've discussed a little bit about national human rights institutionalization in the previous panel. But then again, the international human rights system has to do its part in order to facilitate this. As to your specific question, so the treaty body strengthening process started in the late 80s with the Philip Alston report. And as the Austrian ambassador said at one of our recent events on the matter, treaty body strengthening is something that is there before you, stays with you throughout your career, and will continue after your retirement. But I will limit myself to the most recently proposed changes and the process that us at the Geneva Human Rights Platform have supported through our ongoing research-based policy advice, submissions, pilot projects, and events. I'll divide this first presentation in two. I'll bore you just a little bit with the timeline first of the latest steps, and then I've picked for you a couple of interesting recommended changes that might indeed change the way we work in the treaty body review space. So the latest stage of the treaty body strengthening process is what has come to be known as the Treaty Body Review 2020 process, initiated by former High Commissioner Navi Pillai's report of June 2012, and the adoption in 2014 of General Assembly Resolution 68268 on strengthening and enhancing the effective functioning of the human rights treaty body system. And it is this resolution that contained the first, let's say, practical series of objectives towards the strengthening of the system, as well as a precise 6-year timeline for reviewing process made of its implementation by both member states and the treaty bodies, through, and this is an important aspect, through an increased role of the meeting of the treaty body chairpersons. In 2020, the final report of the co-facilitators of the 2020 Treaty Body Review process, Switzerland and Morocco, was submitted to the General Assembly with a number of key recommendations. So we're going from a more general, objective-like kind of situation to a set of key recommendations. Now we fast forward to just last year at the 34th annual meeting of chairpersons of the human rights treaty bodies. That aspect in New York, that meeting represented really a critical opportunity to advance on the strengthening agenda. And on that occasion, the chairpersons unanimously agreed on the need to operationalize, finally, the recommendations of the co-facilitators report on 3 main pillars. The first is the development of a predictable schedule of reviews. The second is the alignment of working methods. And the third is digitalization. The last aspect of this timeline is that at the request of the treaty body chairpersons, and towards this year's annual meeting of the chairpersons, which took place literally 2 weeks ago, the OHCHR published a 100+ page working paper entitled Options and Guiding Questions on the Development of an Implementation Plan for the conclusions of the treaty body chairs at the 34th meeting. And these options cover the 3 pillars of the chairpersons that I mentioned earlier on, and add technical details needed to put the chair's guidance into practice. So we're really at a crucial step here in the treaty body strengthening story. In the few minutes remaining for this first part, I'll just go through just a few of these changes that, as I said, might indeed change the way that we work. So under the first pillar, the development of a predictable schedule of reviews, the chairs unanimously agreed to an introduction of an 8-year predictable schedule of full reviews with follow-up reviews in between. And this is a pretty major change, if you ask me. And within the working paper, there are 3 options that are proposed for such an 8-year predictable schedule of reviews. The first, option 1, is what they call linear reviews, meaning that if, say, a state party ratifies all 8 treaties with periodic reviews, 1 full review would generally take place every year. The second is partial clustering. And what they mean by that is that the reviews under the covenants would be scheduled back-to-back in 1 year of the 8 cycle of reviews to strengthen the indivisibility of the rights of the ICCPR and the ICESTR, with the other 6 full reviews taking place sequentially. The third option, that is what is called full clustering, the reviews of the 2 international human rights treaties with periodic reporting procedures would be undertaken back-to-back every other year. I know it's quite complicated, but upon reading these, I think that one understands the logic of it. And in essence, covenants and conventions would be paired, where rights are similar, overlap, or are traditionally addressed by the same national authorities or stakeholders. So here we see that replacing the unpredictability of the current system allows states and other stakeholders to plan with certainty, something that I'm sure colleagues in the call that are working towards the reviews have had a lot of trouble in developing. Equal treatment of states parties in a predictable schedule of reviews ensures full reporting compliance and no accumulation to and you know the big backlog that the system is facing. And finally, increasing the complementarity of reviews would also reduce the duplication of issues raised by the treaty bodies. Now, just a few words on the other two remaining pillars. On the harmonization of working methods, this is something that we at the Geneva Human Rights Platform, but many colleagues here in Geneva and elsewhere have been working on. It seems easy to say, right? You harmonize the working methods of the committees, meaning same timelines, the same word limits and so forth. This hasn't happened yet, regardless of the fact that, again, the treaty body strengthening process started in the 80s. So the OHCHR proposes to establish a coordination mechanisms, finally, under which the decision-making by the chairs of the treaty bodies becomes conclusive in this area, with support from the focal points on working methods. So here, of course, it would facilitate the engagement by states, parties, and other stakeholders with the system, while considering the specificities of each treaty. It would allow states, as well as other stakeholders, to focus primarily on their substantive preparations rather than facing a multitude of procedures and deadlines that differ between treaty bodies, and would hopefully at some level reduce the reporting burden as well. Finally, just one last word, if I may, Lisa, on the digital uplift. So the working paper, and this is quite an interesting part of it, the working paper proposes several IT tools to move away from the current practices that are characterized by paper and email-based exchanges. And some of these are a common web page and database on the simplified reporting procedure, common and user-friendly submission and document management platform. So finally, we'll have a website where we'll be able to submit alternative reports or state reports instead of emailing them as we currently do. A collaborative online drafting platform for treaty body members and secretariat staff, because of course our work outside of the system is difficult. But again, once you're in the system, it is also quite complicated to receive all these documents, and an automated establishment of a list of documents on the human rights developments and progresses of states parties. I think my time is up, but of course, perhaps I can touch upon some of these during the later part of the session. Thank you.
Thank you so much, Domenico. I think despite the kind of complexities that you referenced, it's, I think, still clear that some of these changes could reduce duplication of efforts and simplify things in a way that facilitates engagement. It makes me chuckle, of course, about the IT tools, because some of these things seem so obviously useful and overdue, but it's great to hear that there's progress being envisioned. Karen, it would be great to turn to you at this point to get your response on the issues that have been raised so far. If you'd like to address, for example, how the US government approaches coordination for the treaty body reviews, or how that engagement might differ from the domestic realm. Thank you.
Yes, thank you, Lisa, for having us. And I want to extend the regret of my colleague, Jonathan Smith, who was originally scheduled to come, but had to leave Washington and regrets not being able to be here. And I really appreciate the opportunity to be here with the panel and the guests. There's several folks here on the participating today, and others that were some of the first people that I worked with on these issues on some earlier reviews. And I really learned a lot from earlier sessions of the CLE program and all of the work with them. I'll start just talking at a really high level from the inside of the executive branch, how preparation looks for us. Then if there are specific questions, I'm happy to go into it. But I work in the Civil Rights Division at the Department of Justice. And so many of these issues, and particularly the issues that are under review at the CERD, the Convention on the Elimination of Racial Discrimination, are really core to the work that we do every day in the division. And so what's different for us about the treaty process is that it's organized at, in terms of how we're all brought together and how we prepare reports and prepare and attend consultations. It's really organized by the State Department, and that's not, of course, typical if we're looking at an issue in our more typical domestic work, that's come up in Michigan or California, or if a group comes to us, we're working with them directly. We're working with our colleagues in other agencies like the Department of Education or the Department of Labor or the EEOC. But for the United States, I guess because these committees and the treaties themselves, the ratification and reporting and filing of things is really done by the State Department, both the Office of the Legal Advisor here in the United States, by the US Mission in Geneva, takes a lead role, and the Bureau of International Organizations, which has a lead role, throughout the government on dealing with multilateral bodies. So that's something that's very different. If you're sitting in one of the agencies, you don't get a lot of emails from the State Department, but they call us all together. They set out the schedule for us in terms of, the date that the report is due and the recommendations, sharing with us. And again, we see them when they come out, but sharing with us again, the recommendations and the list of issues that have come from the committee. And from the last review, we meet internally just about the logistics and the process and share drafts. And if anyone has had experience in the US government or another government, you can imagine how that process goes. Once that starts, it's not that different from other efforts. But again, it's the State Department and a contractor that works with them that's really kind of coordinating and pulling together the report and, doing the final draft and getting it cleared by the National Security Council and anyone else who needs to review it on behalf of the whole administration. So that's very different. We have what they call, interagency policy committees, and they'll form one about the treaty and have periodic meetings. So that's a little bit of the process. And it's similar for the presentation itself, again, because of the diplomatic protocols, because it's the mission that really leads the delegation and takes care of it. They, again, are leading the process of, in the first instance, telling us, who they think should be on the delegation at an agency level, not specific people, but what agencies they would like to see there. The administration and the State Department have discussions and give suggestions about the size of the delegation, that they would like to see traveling. It's been very important to the State Department to have representatives of state and local governments in the last several reviews. And again, it's in consultation with us. They usually determine, how many and who those representatives are. And again, take the lead in coordinating the process of getting everyone together, thinking about what questions might come up, who's prepared to address those questions, and getting us all there and back together. In terms of the substance of the reports and the interventions, we really draw on the work that we are doing in the United States in our domestic agency capacities, because it is about implementation, in the United States. And so we draw on, the work that we've been doing, the questions that have come up, our engagement with, NGOs and advocates and communities around the country to inform, what we actually say. For a country as large as the United States, and with the breadth of questions that we get, there's always a tension, between covering everything and the amount of detail, that can go into a report given page limits. And so again, it's the State Department and others that often will try to bring all those things together and make those calls. I'll stop there. If there's anything else specific you'd like me to talk about or that I've missed, please let me know.
Thank you, Karen. Thanks so much. Yeah, a lot of similar challenges in terms of what civil society faces in condensing and synthesizing and bringing together all this information as you face, it sounds like. I'll turn now to kind of the follow-up and the impact phase of an importance of the review process. We might have to give a little bit shorter answers this round so that we can leave time for questions. And before we do that, though, I'll turn to you, Jen, for the next code for New York. Thanks.
Thank you. So the next code is N, as in noodle, sorry, X56L8. That's NX56L8. Thank you.
Thanks, Jen. And now we all need some noodles, so I'll be thinking about that. Okay, so a little bit of a tighter timing here on this second round so that we can have questions. But Elisa, I'll turn to you first with a question on how local organizations and governments in the US facilitate implementation, either of the ICCPR itself or the recommendations coming out of a treaty body like the Human Rights Committee, and what role IORA can play in advancing those efforts locally. Thanks.
Yeah, thank you, Lisa. So the ICCPR as a mutual treaty commits nations to respect the civil political rights of individuals, and it enables people to enjoy a wide range of human rights, including those related to equality and non-discrimination. So local governments have a critical role to play in advancing human rights protections domestically, and that nexus is at the heart of existing partnerships between IORA and the U.S. human rights advocates and overall. We often have community connections that are essential to effective human rights protections. Similarly, local governments are well placed to educate and raise awareness. And also they serve as a bridge between communities and other government entities, as well as non-governmental organizations as well. State and local human rights commissions serve a variety of functions that align with the ICCPR human rights standards. We seek to prevent discrimination, to enforce anti-discrimination laws, make policy recommendations, foster positive community relationships. So our mission and mandates are compatible with the international human rights standards. Many local commissions regularly use international human rights principles in our work. IORA member agencies have used the Universal Declaration of Human Rights, or the UDHR, as a basis to gather information and data on emerging civil rights issues within their own communities. The U.S. supported the U.S. supported the Human Rights Committee recommendations to incorporate human rights training and education strategies in their public policies. So federal officials stated that programs at the federal and state levels providing training on human rights, particularly on issues related to civil rights and non-discrimination, and that they were working to continue to explore ways to strengthen those programs. So IORA also plays a critical role in strengthening those programs by carrying out anti-discrimination education and training and awareness activities, including human rights education to governmental officials at the state and local levels, and partnering to bolster respect for human rights among the business community. I recently spoke with my good colleague, Joanne Comlis-Ward, who I think is on this symposium today. She is from the New York Human Rights Commission and a longtime IORA member. And she shared with me some research conducted by the Columbia Law School Human Rights Institute, where she noted that 52 states and local leaders representing cities and towns took steps forward to embrace human rights. These were mayors and state representatives and agency leaders who agreed that it's imperative to recommit to the international human rights framework. and they committed to promote inclusive democracy and protect and respect globally recognized rights. A number of cities have also adopted human rights treaties, translating global ideals related to gender equity into local practice. Some state and local commissions and mayors and legislators are promoting the rights to fair employment and affordable housing, and other governments are adopting a human rights city status. As an IORA member, we are at the table helping to build the capacity for state and local governments to operationalize human rights principles right here at home. So IORA member agencies are an integral part of the network of government leaders working directly with community nonprofit organizations, civil rights organizations, anti-hate groups, community service and faith-based groups, realtors and housing providers, financial institutions, community neighborhood associations, local police and fire departments. I do trainings all the time with those local departments, city and county governments, state and municipal court systems, the legal community, like the group that's here with us today, schools and universities, and the business community. So I'm really proud of the IORA members because our agencies convene thousands and thousands, and we also participate in thousands of human rights town hall meetings, discussion panels, community events, listening sessions, think tanks, research studies, task force, you name it, and even training conferences. In fact, I'd like to personally invite all of you to the 2023 IORA annual conference that's being held in Bethesda, Maryland this summer on August 13th through the 17th. And I put in the chat earlier the website to go visit if you'd like to learn more about what we do at IORA and how you can become involved. You would go to iora.org to register. Thank you.
Thank you so much, Elisa. And as you mentioned, Joanne and Britton have also put some examples of local efforts in the chat as well. Domenico, speaking of kind of this local focus, this proximity, you've been part of piloting some locally held meetings on follow-up of treaty body recommendations, such as in Freetown, for example, Sierra Leone, instead of in Geneva, Switzerland. And in that vein, I was hoping you could tell us more about some of the initiatives that are focused on increasing the accessibility and the visibility of the review process that could lead to better or more coordinated implementation in the aftermath.
Of course. Thank you, Lisa. So this question allows me to talk about two initiatives that we have ongoing here at the Geneva Human Rights Platform. The first is, as you mentioned, the follow-up review pilot series. So as I mentioned earlier on, within this introduction of an 8-year predictable schedule of full reviews with follow-up reviews in between, I didn't stress enough the importance of these follow-up reviews in between. As you mentioned at the start, recommendations under the follow-up procedure, these are essentially 2 to 4 recommendations clearly identified in a paragraph, right at the end of the concluding observations that require either immediate attention or can be implemented in a shorter time frame. Now, the follow-up review as it stands is based on correspondence only, right? This offers simplicity, continuity, and is indeed a low-cost option. In the working paper that I mentioned earlier on, so these options towards an increased effectiveness, there is an option to allow these follow-up reports to be undertaken under the current correspondence-based manner with an additional constructive dialogue. So we see an additional level of interaction, potential interaction between domestic stakeholders, including, of course, the government and the treaty bodies. Under option 3, and this is what we have piloted, the assessment of follow-up recommendations could be undertaken as an in situ visit, so a little bit like the special procedures mandate holders do, to the state party by a delegation of treaty body members and secretariat staff. So this, of course, would maximize visibility and engagement at the national level. Right now, even though it goes against our own interest as a Geneva-based organization, the system is perhaps too Geneva-based. This option, however, would entail a bit more of a time-consuming and cost-intensive, organizational preparation. Regardless of that, as we do here at the platform, we have piloted 2 of such in situ follow-up reviews, as you mentioned, in Sierra Leone, in Freetown in 2021, and in St. George's, Grenada in 2022. And here I will place the reports of these 2 pilots in the chat. We really saw the benefits that this could take in terms of engagement, strengthened capacity of national human rights actors to engage with the treaty body state reporting procedure, increased access for national stakeholders. It promotes cooperation amongst national human rights actors. Having a delegation of treaty body members in capital would, of course, allow many organizations to engage directly. It is currently, I would say, unfair of many countries that the system is based in Geneva when there's governments that are placed, say, in small island developing states of the Pacific that have 24-hour flights to get. So we're really working on that aspect, seeing whether this third option of a follow-up review could eventually be part of the official process. And on the other hand, it would also, of course, increase the contextualization of the recommendations by having treaty body members in country, as well as strengthen visibility of the treaty body system. We are currently in the process of piloting a third and final initiative in the Pacific region in Suva, in Fiji. Now, just a couple more words, if I may, on a second initiative that may facilitate, that works towards a facilitation of better and more coordinated implementation, and that goes to the digitalization aspect that I spoke to earlier on. So I'm proud to say that Lisa is part of the advisory group of a project that deals with digital human rights tracking tools and databases. Across the world, there are a number of tools and databases that deserve more attention and I think are less used than they should. And broadly speaking, the introduction of these digital human rights tracking tools, I can mention the National Recommendations Tracking Database led by OHCHR, but of course there's also the Simore Plus that has been developed by the Paraguayans and is being used as well by the OAS for the Inter-American system. We've mapped more than 50 of these tracking tools and databases. WADZI is another great example of the database that includes human rights information, more of a data collection tool. And these softwares essentially allow to track and thematically cluster recommendations and decisions, link specific recommendations to the SDGs, identify responsible government ministries or agencies for their implementation, develop follow-up plans within the system, and manage information regarding the implementation, as said. So I'll put in the link a number of in the chat, sorry, a number of links to the effect of both projects. Lisa.
Great, thank you so much, Domenico. And yeah, what you've said really highlights that access in terms of both participation and information is so critical to the success of these reviews and their impact. We only have a few minutes before I want to turn to questions, like 2 minutes. But Margaret, I was hoping you could kind of build on what you were saying earlier about some of the successful examples and give us some guidance in how those might be replicated through the implementation phase. How can organizations kind of get involved and what are the tips for successful change using recommendations or other outputs from UN bodies?
Sure. 2 minutes. Let's go. So I'm going to suggest that there are maybe 5 or 6 ways in which civil society organizations typically get involved. As we're thinking about the ICCPR review in the fall, some of these are already passed, so they're not as relevant, but I'll mention them briefly. One is to try to influence the list of issues that the committee presents to the government that's coming under review. Those are the issues that the committee members think are most important and particularly are asking the government for information and updates on what's happening. civil society can play a role in directing the committee members to pay attention to things that they might not otherwise be aware of. The second option, which has already passed as well, is to prepare shadow reports. And that's the opportunity to actually provide reports on the issues that the committee has identified and perhaps include information from the local or city level, the state level, or perhaps regions of the country that can fill in more details. Since both of those are passed, let me get into what is still possible for the review this fall. First is to actually participate in, maybe attend the various consultations that the US government is holding with civil society. While these are generally to enable the US government to know what is coming at the review, it's still useful for us. One of the most important things is for civil society to participate and identify those government officials in the room who would be great for you to follow up with and try to work with on your specific agenda. So participating in those consultations actually gives you information that can be helpful. Then it's actually going to Geneva for the review, or at least observing it, the proceedings when they're live streamed. I think if you're participating in person, what's most important is to bring voices of directly affected people to the conversation. That is something that we're trying to do at the Southern Poverty Law Center. Is not necessarily for us to be the people bringing the information, but people who have experienced, for example, homelessness or incarceration, and who can talk about the experience from a firsthand perspective is really incredibly helpful for the committee members and the staff to hear. And so thinking about how to integrate those, whether through briefings or in the formal proceedings, is a really important step. Lastly, and most importantly, once the concluding observations of the committee are released, it's vitally important that that not be the end of the process. We need advocates to take those recommendations and go and speak with US government officials, as well as state and local officials, as Elisa has so clearly laid out, what they need to be doing to ensure the US is in compliance with its treaty obligations. So those are just the first step. All of us have the responsibility to making sure that we hold our elected officials accountable to actually fulfilling the obligations of the treaty and to using these recommendations as a tool for improving our compliance moving forward. Look forward to questions. Thanks, Lisa.
Thank you so much, Margaret. And I would echo what you said about the importance of personal experiences in those in-person briefings. And you can see sort of the hearts and the minds of committee members changing when they hear directly from people who are affected. Karen, you'll have the last word before we open the floor to questions. If you'd like to respond to anything that's been said, or perhaps give us some further insights on how the Biden administration views implementation and follow-up.
I'll try to be quick so that we can get to questions. I think, one key point for us in the government, and I think for civil society as well, is, what is the coordination? What is the unifying mechanism for this? And I think we've been trying to engage not just the State Department and the National Security Council, but, the Domestic Policy Council and that side of the White House in the process, because a lot of the questions that are very important and that are raised really don't go to just one agency, and it's hard for us to speak to those questions, on behalf of the government. And so I think, that's a good point, for all of us to be raising and keeping visible. I think all of us are very interested in understanding what makes the consultations meaningful for civil society and the people who are there. We've, tried different formats in the US and at the actual consultation in Geneva. But I think if you have suggestions or experiences or things that you would not like to see happen, again, to go to Margaret's point, this is something that I think there's still room to talk about. And I think many of us are interested in trying to have more of a dialogue and sort of shared expectations and goals for the meetings to make them productive. Everyone is we understand, working and traveling a long way, and we want them to be meaningful and helpful. And so if there are specifics about that you'd like to share in the consultations or outside, this is a really good time to bring those to us. And then the last thing I would say that's helpful for those of us who work regularly on these international human rights issues in our agencies, but importantly for our colleagues, because I'm not doing all the work of the Justice Department that's there to implement these things. And I have a much better understanding than I did 5 years ago. But I'm also trying to educate my colleagues. And I think to the extent you can link the human rights recommendations and implementations to the US, law and policy goals and standards, I understand the desire and the importance that's attached to having the human rights treaties and obligations recognized and understood, on their own. But I think for many of those colleagues working in the agencies and in government, if you can pull them together, it will make it easier for them and will give them two reasons. It gives them sort of more of an understanding about how these things are tied together and how it really is consistent and can further their work and isn't just something that's a separate process that comes up every 4 years and then they won't hear about again. And we could all do a better job about educating, our executive branch officials and others on these obligations. But if you can make those links for people, I think it would be helpful.
Thank you so much, Karen. That's, I think, very practical and useful advice. So we have time now for questions, and I think there have already been a few, some on kind of practicalities about when the upcoming opportunities are for participation, both before the Human Rights Committee itself and also with the US government on consultations. So I think we can respond to some of that in the chat. Andrea, to your question in the chat regarding July sessions, those are the consultations rather than meeting with the committee itself. The committee will hold its briefing with civil society in October, and the written reports ahead of that are due in September. And I'll put in the link if it's not there already for more information on that. Let's see. Questions in the chat here. So some comments about accessibility. And then from Martha, is the federal government considering returning to field hearings instead of conference calls to gather info from civil society? Karen, I suppose that's a question for you.
I think in my experience, the field hearings were really part of the Universal Periodic Review process and not as much a part of the other treaty, covenants and conventions process. And I think, the process in the last Universal Periodic Review was limited in large part because of COVID and budget. But I think, again, we would be open to I assume people would be open to that conversation. But again, I think there have usually only been field hearings for the Universal Periodic Review in the past. And the next one, I think, is in 2024 or 2025.
So that's not really an open discussion for this review, it sounds like.
No, I think the next consultation is being done virtually. And those other consultations, there had been an in-person option sometimes in Washington, D.C. But I think the advent of video conferencing has made it possible for more people to participate around the country. So I think people perceive it, as pros and cons. But again, if people have feelings about that and would like some in-person options, I'm sure people would, be interested in hearing them.
That's great. Another question for you, Karen, regarding the state report. The government response to the list of issues was submitted by the Trump administration just a few days before that administration ended. And the question says, was deeply regressive on a number of issues. There have been calls by civil society for the Biden administration to submit an updated response and or to repudiate some of the content of that prior report. Has the administration responded to those calls, or does it plan to respond to those calls?
I can't speak for the administration as a whole. I can say that, we're getting very close to the October presentation, and I have not seen any, requests or activity related to preparing another written report for the ICCPR in this round. I think people would probably point to, executive orders and other clear, policy changes, but I haven't seen any activity around filing a different report. And again, for continuity and reasons, I don't know that we would particularly want that to happen if we say file a report, at this administration. So I think there are also pros and cons there to doing something like that.
Thank you, Karen. We have another question or a comment related to sort of accessibility and who is able to go to Geneva to participate in this process in person. And I'm wondering, maybe from Margaret, from Domenico, from Elisa, if you have ideas or suggestions on ways in which we could collectively make that process more accessible to people from underrepresented groups or those with lower resources, so that they can be part of the process in a more meaningful and in-person way.
Thanks for that question, Lisa. And it is a really vitally important question. I think in the past, the U.S. Human Rights Network previously coordinated the participation of many of the U.S. NGOs and often created scholarship funds to bring activists, particularly grassroots and community activists, to the discussions in Geneva. Now that the network no longer has that capacity to do that, I know other organizations are thinking about it, including the Leadership Conference on Civil and Human Rights. And of course, we at the Southern Poverty Law Center are also thinking about that. But I think to the extent that people have proposals for the voices that they think are most important, I would definitely reach out to any of our organizations, to the SPLC, to the Leadership Conference, frankly, to any of the folks on the call. And we would be happy to try to look for those opportunities. I know too that the US government has on occasion included civil society delegates on their delegation. I'm not sure you're still doing that, Karen. You may wish to speak to that.
This question had come up, and what I recall is us bringing Lisa's predecessor, Robin Thoma, as part of a delegation, but I cannot recall right now if he was formally there in his capacity as a, state or county official of California, or, in his capacity as the head of IORA. I know that we have included, mayors, state attorney generals. So we've definitely consistently included state and local government officials, but I honestly am not sure that we have had a true civil society representative as part of the delegation, because it's a government delegation. But that's my experience.
It might also be worth talking to your funders and your supporters about the value of having representation in the discussions and in Geneva, and happy to offer some advice to anybody who's interested in doing that.
Thanks, Margaret. Domenico, I'm wondering if you've seen kind of, Elisa, sorry, were you jumping in? You're muted, I think.
Did I?
Oh, I think someone might need to unmute you.
Okay, I think
there you go.
Muted me. But I wasn't talking. I don't know why. There's a signal there. I just wanted to weigh in on what Karen said. Yes, you're correct. Robin Thoma, our previous president, did in fact attend the proceedings in Geneva, probably over a decade ago. But I think that has, in his capacity, heading up his human rights agency in Los Angeles County, and then also in his capacity, I think, with IORA as well, because he's been with us a long time. So we do want to kind of keep that synergy going. So that's an opportunity really to represent the whole nation of human rights practitioners, in the U.S. And so I'll have to talk to you, Margaret, about ways to figure out how to do that.
Thanks so much, Elisa. I think we have time for this last question, again for you, Karen, and how you would respond to the call for a study commission on the establishment of an NHRI, which could make some of this work easier, and who and how civil society should engage with to advance that effort.
No, thank you. This has been a recurring call, and I am familiar with the calls for a study. Again, that is more of a whole administration, full government response. It would require a commitment, I think, from, at the level of the White House to really have a commission that would look at that holistically. I think one thing that I've been giving some thought to, and that I think, again, can be helpful, is, again, making those connections and that nexus between what the international obligations or commitments or NHRI would do and the domestic space and experience of people here. I do a lot of work on hate crimes, and we've been really thinking much more in the last 3 or 4 years about not just criminal prosecutions, but victim support and how you address hate and hate incidents and discrimination that doesn't rise to the level of a formal hate crime, and the gaps, in having a reporting system that relies on law enforcement reports to the FBI as our official US government reporting. And so I think there are opportunities, and I would again encourage, organizations and advocates to bring these tools and questions to us, outside of the formal treaty processes, and really talk to people about what a national human rights institution, for example, might be able to do, in the context of some of these more specific policy and justice and human rights conversations. Because I think, again, when people can see the ties to the work they're doing, it becomes more concrete, and it becomes something that's being driven, on both tracks, and there's more of a connection. So I again, that's all I can say from my experience. But I think, repeating it and making, again, specific examples of what could be done that's not being done now, or what would be better, would be compelling.
Thank you so much. And Domenico, we have a couple minutes left, so I'm wondering whether, since we have you here in the kind of comparative perspective that I think you can offer, if there are examples that come to mind for you of practices in other places that have been interesting or successful in terms of the access piece or the NHRI piece, or any of these things that we've been discussing that we could learn from other places.
Sure, absolutely. Thank you. Thank you for the opportunity. And in fact, it is a question that myself I wish to pose to Ms. Stevens. Since a number of years, both at the Human Rights Council, but as well at the treaty body level, there's been an increased attention and numerous recommendations for the institutionalization of national mechanisms for implementation, reporting, and follow-up. So, of course, let's be clear, we distinguish the two roles. A national human rights institution is independent, and NMIRF is a government structure mandated to coordinate and prepare reports. Now, we know that there's a plethora of NMIRFs out there. We will have here in Geneva on the 23rd now of June, a one-day seminar on NMIRFs. And this is is part of a series of two one-day seminars on the topic mandated by Human Rights Council Resolution 5133. Now, the combination of a strong civil society constituency, a national human rights institution, and a national mechanism for implementation, reporting, and follow-up is the perfect constellation. Now, the strong civil society part, we know that the US has very much. I mean, we can see also the amount of people that are in the call, that have been in the call today. We know that the NHRI might be something for the future. My own country, Italy, does not have one, and we are working also for the institutionalization of that. Does the US have a process for an NMIRF establishment in the future? Do you have one? This is really something that I'm not aware of, and it might be something that could eventually lead to more engaged and more streamlined reporting and implementation and follow-up.
I am not personally as familiar with the National Human Rights Mechanism for Follow-up as I am with the structure of a national human rights institution. So I'm going to go out on a limb and say I don't think we have one. And I'm not sure what that would look like. I think one of the constant challenges for the United States in this arena is, just our federal system and, gathering everything together. So I think that would be, in my experience, sort of a new and sort of second conversation that hasn't been a focus. There certainly has been a focus on there should be implementation, there should be follow-up, what will happen. I know at the CERD, one of the State Department co-chairs of the delegation made a commitment to have quarterly consultations, at least as follow-up, and that hasn't happened so far, but we do have that in mind. And at Justice, we've been having conversations about whether we should have a Justice Department, kind of follow up to the CERD if there isn't a wider interagency follow-up. But those are, again, more conversations, and nothing has been decided or shared externally or with us that I know.
Thank you so much, Karen. This was a really thought-provoking and interesting discussion. I'm really grateful to the four of you for your candor, for the relevance and the practicality of all of the suggestions that you have brought. So thank you very much. And Martha, again, thank you to you. And I'll turn it back over to you.
Great. Thank you. Thank you, Lisa. Thank you to our speakers on this panel for their insights, to Lisa Reinsberg for this excellent moderation. I will say one of the issues that came up on an earlier panel was whether there were places where the US or civil society should be engaging that we weren't. And I think we've heard today about the dialogue around the NMIRF as well as the NHRI, places where there maybe are opportunities for civil society as well as the government, and that we're losing out by not being at the table for those. So we've reached the end of the program today. I want to take a few seconds once again to thank our colleague organizations that served as co-sponsors for this program, and to thank the wonderful speakers that participated today. I hope that for those that are on the call, that listening in will inspire you to get involved in using human rights processes to help ensure US implementation of human rights here at home, and not only during the upcoming ICCPR review, but going forward into the future. And to go back to the Rocky Road image, your engagement is important and necessary to move us further along the Rocky Road and maybe over the rocks, to the summit. So thank you again, and goodbye.